My lord, I'm
No,
a member.
what is the subject matter first?
My lord, I'm a member of the compensate, my lord. I was removed without any notice. Later on, my lord, I became president, my lord. So I
When is the order?
that order is, my lord, 21st of, my lord, July, my lord.
Tomorrow.
So I free, my lord.
Tomorrow.
Obliged, lord.
Lord, motion item for eviction tomorrow, my lord. Obliged, my lord.
Happy Lordship. Admission matter, my lord. Last on 29/4/2026 was listed.
Please give it to the court master.
Lordship. I love first.
Lordship, the motion item for 3rd of August, Lordship.
Motion.
Motion.
Lordship, I beg to mention item number 45, Lordship. In this case, Lordship, contender number 1 has been transferred, Lordship. So imprisonment petition may be filed, Lordship.
45.
45 item number.
Hmm.
The contender number 1 has been transferred to somewhere else, Lordship.
Mr. B.U. Laskar,
Yes, Lordship.
learned counsel for the petitioner, has submitted that in view of transfer of an incumbent who has been read as a respondent in the contempt petition, an interlocutory application for implement has been filed and has already been filed, and therefore this matter be listed on another date with the interlocutory application for implement. First of it is submitted that you have informed the other sides.
Yes, Lordship.
Okay. It is submitted that the consent has been taken from the learned counsel for the respondents to make the prayer, list the case on a date in the next week, along with the interlocutory application
Yes, sir.
for implement.
My lord, an eviction matter for motion, my lord. Can it be listed this Friday?
Eviction matter,
Yes, my lord.
motion.
Motion for motion. Obliged.
Lordship, item number 25, my lord. On the last occasion, there were some instructions to be brought by the bank because they had gone and filed an appeal against the recovery officer's order. I'm seeking a week's 10 days time, my lord. I need to put it in affidavit. I've already spoken to Mr. Ganguly. He's agreed for it. If it is not inconvenience
Okay.
for a week.
Mr. R.B. Phukan, learned counsel appearing for the petitioner, has sought accommodation to file an additional affidavit to bring in subsequent developments
Yes.
on record. First of it is submitted that he has it is submitted that consent has already been taken from the learned counsel for the respondents to make the request. First of list the case accordingly on
17th August,
after
1708.
There's an interim order which
the interim of the past earlier shall continue
I'm extremely grateful.
till the next date of list.
I beg to mention item number 8, Your Honor. Kindly adjourn
Item number
8, Your Honor. Kindly adjourn this matter. This matter may be come after 10 of August, Your Honor. Any date.
why?
August, Your Honor.
You are a petitioner?
Yes, Your Honor.
Counsel for the petitioner?
Yes, Your Honor.
You wait. If notice is to be issued, we will issue notice, otherwise we'll adjourn.
Yeah, please.
Hmm.
I prefer mention a matter for withdrawal tomorrow.
Okay.
Obliged.
May please, your lordship. Lordship, with the consent of the order set, I beg to mention item number 29, lordship. We need 1 week time to file affidavit in reply, lordship.
Miss
B.S. Ojha.
learned counsel for the petitioner has sought for and is granted to a week's time to file an affidavit in reply. Who is there? You have informed?
Yes,
yes,
sir.
Lordship, kindly.
Okay.
Response
Mr. A.M. Doctor.
Lordship, interim order is
So
due.
for the respondent number 5 to 12 is present. It is submitted that consent has been taken from the learned counsel for the other respondents to make the prayer. Leaves the case after a week on a date to be fixed by the office. The interim order,
Lordship, 13th of
clear,
August.
if any, shall continue till the next date.
13th.
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 30.
Yes.
After affidavit. 20.
Yes.
Lordship, I beg to mention a fresh petition for listing. Pertains to a panchayat matter. What had happened was that I was originally settled with the market. Thereafter, the
Market bench 4 perhaps. Market is bench 4. Settlement of market is bench 4.
Obliged, Lordship.
Maybe those. My lord, item number 46, my lord. I may be allowed to withdraw, my lord. Since the, my lord,
Okay. Mr. A. Hussain,
yes.
learned counsel for the petition has submitted that has submitted on instruction that the petitioner does not want to press the writ petition. Mr. J. Hendrick, Learned Standing Counsel, Revenue Department, and Mr. S.S. Roy, Learned Junior Government Advocate for the official respondents, are present. State respondents are present. In view of the above submission made by Mr. Hussain, Learned Counsel for the petition, the writ petition is dismissed on withdrawal as not pressed.
Obviously.
May I please, your lordship? I beg to mention item number 16. Kindly pass on.
1-6.
Yes.
Wait, we'll see. Motion matter.
Daily list for motion, item 1.
At this stage, you will issue notice.
But then, my lord, on the last occasion, I submitted one judgment on the basis of
I
that.
have also gone through.
My lord.
Heard. Mr. A.R. Punia, Learned Senior Counsel, stated by Mr. Learned Counsel for the petition. Whether this petitioner was a petitioner earlier?
No, first time, my lord, first time. He is already being evicted, my lord.
Mr. S.S. Roy, Learned Junior Government Advocate, Assam, for the response number 1, 3, 4, 5, 6, 5, 8, 10, and 11. Mr. A. Aforesaid, Learned Standing Counsel, Revenue Department, Government of Assam, for the response number 2. Health, Ms. D. Bora, Learned Standing Counsel, Health and Family Welfare Department, Government of Assam, for the response number 6, 7. PWD. Mr. A. Sorwa, Learned Counsel, on behalf of Mr. P. Gogoi, Learned Standing Counsel, Public Works Department, Government of Assam, for the response number 9. Miss B. Decca, Learned Standing Counsel, Elementary Education Department, for the response number 12. Who are they? 13 and 14.
My lord, they are the person from whom, my lord, I purchased the land, my lord. That's why.
Okay.
Registered post I will take, my lord.
The petition has stated that it purchased a plot of land
My lord. Description for this.
from the respondent number 13 and 14.
3.
And after purchase of the plot of land, and for the said transaction, no objection certificates. No objection certificate. No.
My lord.
Okay.
No, my lord.
Registered sale deed.
no, my
Registered
lord.
sale deed.
No, my lord. By unregistered sale deed, my lord. I was in possession, my lord.
No, what is your status then?
My lord, my status.
Unregistered sale deed.
Unregistered sale deed, my lord, by virtue of this registered sale deed, my lord, my possession had already been given.
Registered sale deed or agreement for sale of land?
Agreement for sale, my lord. This
Huh?
is that page, my lord, I have annexed. My lord.
Had entered into an
75.
agreement for sale of land
My lord.
with the of a plot of land with the respondent number 13 and 14.
14.
Agreement sale of land dated 11/3/2019.
Yeah.
And at the time of the agreement for sale of land, the petitioner paid a part of the agreed sale consideration. Full stop. Thereafter, comma. Paid some part of the agreed consideration to the respond number 13 and 14. Post on the basis of the said agreement for sale of land, comma, the respond number 13 and 14 gave possession of the plot of land to the petitioner. And after getting possession of the plot of land, the petitioner constructed a permanent house structure on the plot of land and had started residing there. First, para. On 25/9/2025, an eviction notice was served upon the petitioner on the premise that the plot of land which was in possession of the petitioner falls within the tribal belt or block.
My lord, chapter 10 area, my lord. Tribal belt.
This notification defines block or mention?
Tribal belt, my lord. Tribal
Belt
belt.
oblique block, both are written.
Tribal belt stroke block. And therefore, the petitioner had no right to possess any plot of land within a tribe, such tribal belt stroke block. Full stop. Thereafter, on 14/2/2026, the house structure constructed by the petitioner on the said plot of land was dismantled by the responding authorities on the basis of the said eviction notice dated 25/9/2025. And as a result, the petitioner got evicted from the said plot of land. Post of para. In this writ petition, comma, the primary challenge in this writ petition under Article 226 of the Constitution, comma, the main challenge is to a notification dated 27/10/1950. Post of seeking alteration stroke modification of the notification dated 27/2/1950 by excluding the village within which the concerned plot of land, excluding a village, Pochonia Para, within which the plot of land is located. Post of a number of other reliefs, a number of other prayers are also made. Including is also made the act of demolition carried out by the responding authorities. And for compensation. Also. By the original notification.
My lord, it is in additional act of
By the notification dated
27 to 1950.
27 to 1950. The state government, the revenue department, in exercise of powers conferred by section 161 of the Assam Land and Revenue Regulation, 1886, as amended by the Assam Land and Revenue within bracket Amendment Act, 1947, had constituted the areas described therein as tribal belt. Block na like. In Gauhati Revenue Circle District, Kamrup. Full stop. It is the it is the case of the petitioner that the factors germane for issuance of the notification under section 161 of the Assam Land and Revenue Regulation 1886, as amended, were not present. Post up. Para. Mr. The Learned Counsel, Mr. Aforesaid, Learned Standing Counsel, Revenue Department, and Mr. S. Roy, Mr. Roy, Learned Standing Revenue Government Advocate Assam, have submitted that the petitioner does not fall in the category of person who can possess land in a tribal belt as declared by the notification dated 27 to 2025, and therefore
1950.
1950. The matter would require consideration. They have submitted that a number of persons were evicted after from the areas within the, what is the name of the block built?
My lord, it
South
is Kamrup,
Kamrup.
in South
Ah.
Kamrup Tribal
Tribal
Belt
Belt.
and Block.
From the South Kamrup within bracket Gauhati Tribal Belt, constituted by the notification dated 27 to 1950, in the meantime, and a number of repetitions were filed challenging such eviction process. So those repetitions were also already decided. Were already decided against the petitioners. Post up. Petitioners therein. Post up. Para Mr. Mia, Learned Senior Counsel, appearing for the petitioner, has submitted that the petitioner has approached this court by the present petition for the first time.
First time, my lord. And my lord, in the earlier petitions, this 27 to 1950 was not a part of the challenge, my lord.
No, I am
Well-
saying that you are petitioner for the first time.
First time.
Otherwise, the question of
My lord, as I cannot come for same prayer, my lord. My lord.
I'm taking your part. If it turns out that if you have earlier come, then your thing is foreclosed. So that is why
My lord.
I'm making this
My lord.
as
Seven.
a part of the order.
My lord.
The matter of required consideration, issue notice. Returnable on, yes, Mr. Aforesaid, 4 weeks or 6 weeks?
6 weeks.
6 weeks, better. Returnable 6 weeks. Better.
9 September.
As so and so appeared accepted. Yes,
Before
9. Okay, PH is there. Your name, please?
Yeah.
PH, huh? Respond number 9. No formal notice, extra copies, 2 working days.
My lord.
Steps upon respondent number 13 and 14 by speed post.
My lord. My lord,
2 working days from today.
my lord. My lord, in some areas, my lord, in wherein eviction had been carried out, this honorable court has directed at least to provide the basic human amenities, my lord. That is a part of the order, my lord. Now I am a homeless, my lord, just residing the roads, my lord.
You were one.
My lord.
You were only one.
Item 7 is also
is
similar.
Let us see.
My lord.
This is my lord. My lord, with respect to item number 1, my lord, the name of PWD may be reflected in the cause list.
The name of
7 to the standing.
Standing Council Public Works Department is to be reflected in the respondent side in the call list. AR of Mia, estate by so and so. Now there are more petitioners.
Yes, yes, my lord.
Have they come earlier?
No, first time.
Petitioners.
Kejon আছে না?
One is
Ah.
1, 3,
31,
4,
32.
5, 5, 10, 8, 10, 11. SS Roy. 2, A Authorised revenue.
Yes, ma'am.
D Bora, health, family welfare. 6,
PHE 9.
7. PHE 9, S Sharma, on behalf of R.R. Gogoi.
Health 7, 8.
B
6, 7.
B Deka, Standing Council, Elementary Education. 12. Para the petitioners,
My lord.
31 in number, have joined together to institute the present petition under Article 226 of the Constitution, stating that they have a common cause of action. Post up. From the pleadings,
5 funds.
made in paragraph 4 of the writ petition in the pleadings. It is stated that all the petitioners are attorney holders
My lord. My lord.
of recorded patadars. Why they were patadars? Why they were not before the court?
My lord, they are, they have not been served notices. No, my lord, hearing had been done to them also, my lord. Only these attorney holders had been issued.
Hmm?
Only to the power of attorney who found in possession, my lord, or taking care of the land, they were heard and notices were served, my lord.
This Kabir Dewan
My lord.
and Rehana Begum
My lord. Are the original
are recorded patadars
recorded patadars.
of a number of plots of land.
Yes, yes, my lord.
Then why separate attorney holders for
No.
the same
My lord, area is,
recorded patada?
my lord, area is big, my lord. That's why a part.
No,
My lord.
what is the reason? Let us have this paragraph 4.
My lord.
Rehana Begum and just I have looked at now, Rehana Begum and Kabir Diwan, only
My-
there are two persons.
2 persons, my lord.
And these 31 petitioners are representing two persons.
No, my lord, what has happened, this Rehana Begum and Kabir Dewan, my lord, has issued those power of attorneys to these 31 persons, my lord. My lord, some of the attorney, my lord, we have annexed. My lord. So annex position.
No, attorney holder is to do certain things
Certain things. my
on
lord.
behalf of the
Exactly, my lord.
right.
Correct, my lord.
Now, whether that those attorneys are allowed to possess those lands
No, my lord.
by the power of attorney.
Yes, my lord. That issues has been, my lord, raised before this honorable court, my lord, in the earlier round of litigation, not by these petitioners, my lord. And this honorable court has held that, my lord, once the by which cannot be done directly, that also cannot be done indirectly also, my lord. So this honorable court hold that, my lord, the power of attorney holder is also amount to change of the possession, my lord. That's why, my lord, it has been constituted that the power of attorney holder by allowing them to reside in a or taking over or taking care of the property is amount to is violation of the chapter 10, my lord. That's the issue, my lord.
So what has been held on locus?
Locus has not been, my lord.
No, what has been observed?
Locus has not been
Because
raised. my
here
lord.
I am finding it a bit strange.
No, my lord, that is correct. my
Rehana
lord.
Begum and Kabir
My
Begum,
lord, Kabir Dewan.
they are said to be pattadars of a number of plots of
My
land,
lord, my lord,
right,
my lord.
within South Kamrup. Now, why these 31 power of attorney holders in respect of two persons? Why they are representing
The pattadars, my lord.
two pattadars,
My
only 31%?
No, my lord.
31
yes,
as
yes.
attorney holders.
Yes, my lord. My respectful reply to that, my lord, is that, my lord, the area wherein this Kabir Dewan and Rehana Begum is there, my lord, is a large scale land and several bighas of land is in their name, my lord, recorded patta.
They are handicapped. These two persons are handicapped to
My
approach
lord,
this court.
now, my lord, I do not have the
I'll
that,
record they are
No.
handicapped.
my lord, I do not have that instruction, my lord, why they are not,
Why this is
my lord.
what
And-
is
and
what
Milo-
can be done
Yes,
directly?
my lord.
So this power of attorneys,
My
they are, why they are making this one tribal belt?
No, my lord,
What is,
my-
what is the reason? Let us. What is the purpose of? Let us see the power of attorney.
Yes,
For
yes, Lord.
possess.
Lord, I
Power
have
of attorney is not to possess a land.
not to possess, my lord.
Then power of attorney act is to do certain
My
things
lord,
on behalf of the
on behalf
petitioner.
of the, my lord.
For different parcels of land, power is given to different 31 persons. Let us see.
Page 104. 104 is a, my lord.
Let us see 104.
The first one. No, it will be very high. Okay, sir. Unregistered sell deed. No, any. My lord, the vernacular is at 104, one of the documents.
সাধারণ আমুক্তানামা
Let us see their original landholders
My lord.
right.
My lord,
Because
in
they
the-
are projecting that they are recorded patadar.
My lord,
Where are
Jamabandi copy, my lord.
Where
I
are
have an-
those?
Sri Rehana Begum is at page 67, my lord.
67.
My lord. And Kabir Dewan is also there, my lord.
67.
My lord. Hmm. Serial 90 and
67.
Begum. Kabir Dewan. Serial number 90, that original.
How much, for how much area they are recorded pattadas?
My lord, that,
Have you mentioned?
my lord, in the translated part, my lord.
No, in the pleading that they
No,
are
no.
total, they are landowners of a total
Yes,
area of
yes,
land.
yes,
Where
yes.
is that?
No, my lord, that statement is missing, my lord.
Hmm,
That statement is not here. my lord.
because,
Yes, that is required, my lord.
where is that?
That is
In the
not-
Jamabandi remarks,
Yes, Jamabandi remarks also, my lord.
Rehana Begum or Ali,
Kabir Dewan, my lord.
where is that page in the Assamese version?
My lord. And the area to,
Because if 31 persons,
yes, it is
Right.
it is a large
so
scale. my
meaning,
lord.
meaning thereby Rehana and Kabir must be landowner of a big chunk of land,
My lord,
right?
That is correct.
31% represent them.
my lord.
So where is that entry in the Jamabandi?
Yes, my lord, that is required, my lord. But
Ah.
it is from the.
If it is 1 bigha, 30% cannot
Not possible.
represent.
My lord, I have heard that it is more than near.
Let us with the
My
fact.
lord, I will.
Let us have the fact. Let us see.
Yes,
In the
my lord.
Jamabandi.
And secondly, my lord, if
Let us see in the Jamabandi, page 69.
69, my lord, Kali Hector, dear my lord.
No, where is the relevant entry?
Yes, my lord, the relevant entry as
Ah.
regards the my lord,
Huh.
Sreni, Kali, Hector.
No, Sreni is not required.
No,
Relevant
Kali
entry.
and Hector is required, my lord.
No, that will automatically come. Where is the remark?
My lord.
Rehana Ali and
Yes.
this Kabir Dewan.
1990. Both are said. Sure. এখানে কি petition?
Is there any statement in the writ petition?
My lord, from the vernacular at page 100, my lord, my learned friend who is assisting me, my lord, has pointed out this part, my lord, 21 bigha 82 katha.
Where is that?
At page 100, my lord, in the right hand column, extreme right hand column regarding, my lord, the column maintained. So. Column
100.
My lord, Kali, Hector, Aru, so and so, my lord. Bigha, Kotha, and Lesa, it has been mentioned, my lord, in the third table. And patta number 39. So in this patta number
Page
39,
100.
my lord,
Page 100.
page 100, my lord,
Which part?
the right part, my lord. The 21 bigha Biraki Kotha Putore Lesa is
No,
there, my lord.
here it is Sakro Bikhoy 26/5/2025 Namjari
No, my lord.
হুকুম মৰ্মে 34 ডাগৰ অংশ মাটি উত্তৰত ঠিকাৰী দখল সূত্ৰে সোণাৰী বা মহলত চিন্তা দেৱী আৰু দীনেশ দাসৰ নামত নামজাৰি কৰা হ'ল।
No, it is.
Page 100.
My lord, total area in the area of this patta has been mentioned, my lord. Now exactly.
Total area under patta,
My
but
lord.
there are so many names.
So many names. So, my lord, exactly, my lord, in the name of.
See,
Exactly in the name of my lord Rehana Begum and Kabir, that is required to be find out, my lord. Because 31 is
because
there.
they know they are owners of how
My
much land.
My lord.
They know.
They knows, my lord.
Oh, why? If we don't,
Lord,
if we
that
are not
facts-
clear,
My lord.
then why, whether these 31 persons are to be roped in a writ proceeding, which is a serious proceeding.
Serious proceeding.
You do not play with the court. So that is why
my lord, I will
there
bring,
has to be clear averment that
my lord, I will bring entire in a, my lord.
because otherwise court is not in possession. We'll go by the statement on
My
oath
lord.
made in the affidavit.
My lord,
We do not verify when 100% join in,
my lord.
but there has to be a clear
My
statement.
lord, I will make that
These
statement.
two persons
My lord.
are landowner of say 10 bighas or 20 bighas,
My lord.
then it is possible to rope in 31 persons.
My lord.
If they are 1 bigha
It is not
each,
possible.
then it is not possible.
No.
So we'll go by the statement made by the petitioners.
My lord, I will make that statement, my lord. I may be given a week's time, my lord. I'll bring those entire facts, my lord.
You are laying challenge to a notification.
Exactly, my lord, exactly.
It is not a case that more the merrier.
My lord.
Everybody joins the lease. It is not a case. Because by the very thing that all are power of attorney holders,
My lord.
well, you should notice no point keeping it pending.
My lord.
Find out their credentials.
My lord.
কি হলো? Paragraph 4 of the briefings made in paragraph 4 of the writ petitions. First of all, it is stated that all the 31 petitioners are attorney holders on behalf of Rehana Begum, Shrimati Rehana Begum and Sri Kabir Dewan. And a statement is made to the effect that Shrimati Rehana Begum and Sri Kabir Dewan are recorded patadars of a number of plots of land, covered by various dark numbers and patan numbers mentioned therein, at village Posoniapara Mauja Dokhin Rani, district Kamrup Metro. Full stop. Whose locus is to be decided? Kabir and Rehana?
My lord, because, my lord, what has happened?
Because we
during-
have to decide the locus of
Locus.
Kabir and Rehana
My lord, because
to have
land in a
lands in chapter 10.
chapter 10 area, my lord. Now, as we are,
And they are,
my lord,
what do we call, in a betel arecana tree,
my lord,
betel tree grows up, which are generally called parasites, whose fate
my lord.
is dependent on others.
Porojibi, my lord. My lord.
Yes. So this appears to be
My lord.
Porojibi,
My lord, exactly.
locus of
my lord.
Rehana and
Kabir, my lord.
Kabir is to be decided.
My lord.
We'll ignore all this.
My lord. Now, my lord,
Challenge
my-
the notification.
my-
They are Porojibis, parasites.
my lord. Caretaker, my lord.
No, caretaker will not. Everything is dependent
Power is-
dependent upon the person who has given them power of attorney.
For particular.
They are
purpose.
nobody.
That-
Interlopers.
That's why, my lord, the entire proceeding, my lord.
No, I'll record it.
Right.
In all the orders, it has to be recorded. Otherwise, we'll lose sight of the main issue. The petitioners have challenged the legality and validity of a same notification, so and so, so and so. Mr. Bhattasaiji and Mr. Roy, learned counsel appearing for the state respondents, have submitted that the core issue, which is to be decided in the present lease, is whether Srimati Rehana Begum and Kabir Dewan have fall in the category of persons eligible to inherit or purchase land in the tribal belt notified by the notification dated 27/2/1950. Post of if the petitioners or if those two persons or their predecessors in interest had obtained lands within the tribal belt after 27/2/1950, then it is the locus of these two persons which will decide insofar as the maintainability of the retribution. You should notice. The matter would require further consideration. Again, likhi dibo tribal belt 27/2/1950. Issue notice, returnable answers. Same thing, same date,
9.
same persons. Extra copies. 2 workings.
9 September.
But this is doubtful. Well, on going through the pleadings, it is not noticed that the
Area of
or,
land.
About the land ownership, sorry, there is no pleading
Total area
to
of
the
land,
effect
Milord.
that what are the total areas of
One.
land wherein the names of Rehana and Kabir Dewan within the Kamrup so-and-so tribal belt are recorded as pattadars. If it is 1 bigger, 31 cannot join.
My lord. I'll sure, Milord. I'll bring it. Obliged, Milord. Deeply obliged.
It is not that like Indian Railways.
My lord.
Everybody who has the ticket,
Ticket, Milord. Can go and board, Milord.
don't buy platform ticket and enter into the
Right.
rail. If they are platform ticket buyers, they have to be chucked out.
Yes, Milord.
Only the main ticket holders who has registered, recorded birth,
Confirm birth, Milord.
confirmed birth, they can only
Fine.
board the train.
Obliged, Milord. Deeply obliged.
For time being, counsel of the petitioner is on leg in another. court,
Hmm?
my lord.
Item number,
2, my lord.
notice issued.
My lord, that's why, my lord, counsel requested me to make the mention before you.
Wife of so-and-so.
Lordship, we have filed our affidavit also.
File affidavit,
Lordship.
is it? Regarding ex officio.
Lordship. The
What is
same-
your affidavit? What is the
the
stand?
Same was rejected by the finance department, Lordship, due to shortage of budget.
Budget.
Lordship.
Yes, Mr.
Also-
Finance. Where are you going? You don't have the purse. 10 lakh. Mr. Gogoi?
It is sanctioned.
A person died doing your election duty. He is a presiding officer in Panchayat election 2017. You have conducted 2 other Panchayat elections, but you don't have money for 10 lakh. Better to have this. The widow is waiting since 2017. He is a government officer. You have the policy. It was processed at different level. Finally, commissioner has also forwarded to accord financial sanction. Now you are saying that this is the pretext. Whatever be the budget hit, 10 lakh is not a, and it is already there. Where is the processing, Mr. Miss?
Lordship,
Papa?
also one instruction we have received.
This Panchayat and Rural Development Department Commissioner, Jalili Kirti.
Lordship, one instruction we have updated. in
Uh-huh.
circular. We have requested the government for releasing the additional budget.
This is matter is waiting since 2025 for financial sanction. State of affair. Heard Mr. H.R. Ahmed, Learned Counsel for the petitioner. P. Thapa, Learned Standing Counsel, Learned Counsel on behalf of Mr. S. Dr. Panchayat and Rural Development Department for the respond number 1 and 2. Mr. B. Gogoi, Learned Standing Counsel, Finance Department for the respond number 3. And Mr. S. S. Roy, Learned Junior Government Advocate, Assam for the respond number 4. Post of para. It is noticed that on 13/12/2025, the Commissioner, Panchayat and Rural Development, Assam, wrote to the government, state government, in the Panchayat and Rural Development Department to accord financial sanction for an amount of rupees 10 lakh against the head of account mentioned therein to disburse the ex gratia amount to the petitioner. Post of agreed by non-disbursement of the ex gratia amount of rupees 10 lakh. The petitioner was compelled to approach this court and the petition was filed on 12/5/2026. Post. Ms. Thapa Para has submitted that during the financial year 2026 to 2027, only an amount of rupees 17.33 lakh was made available in the budget provision under the concerned head and thus there is shortage of available budget to submit the financial sanction proposal amounting to rupees 10 lakh, which is the subject matter of this writ petition. Post of the Commissionerate of Panchayat and Rural Development Department has submitted budget estimate in the under the concerned head again on 11/6/2026 for an additional amount of rupees 35.17 lakh. Was by an letter dated 27/7/2026. The commissioner reiterated its request to sanction and release the additional estimated budget amounting to rupees 35.17 lakh so that the financial sanction, so that the ex gratia amount of rupees 10 lakh can be disbursed to the petitioner. First up, Ms. Thapa has placed a copy of the letter dated 27/7/2026 of the Commissioner, Panchayat and Rural Development Department, addressed to the state government in the Panchayat and Rural Development Department. First of para. Ms. Thapa has further submitted that an affidavit in opposition, affidavit.
Lord-
To that affidavit in opposition has a counter affidavit. On behalf of the responding authorities, Panchayat and Rural Development Department has already. Panchayat and Rural or Commissioner?
From government lordship.
Huh?
So number one,
One.
lordship.
What he is doing? Government, what he is doing? Additional Chief Secretary.
Lordship,
Commissioner is writing.
lordship,
Now he is stating what in the affidavit in opposition.
lordship. It has been stated that the same was forwarded to the finance department, but in
Let us
this
see.
lordship
Let us
is
see your copy.
Financial year.
Let us see your affidavit.
Lordship. Please, lordship. 45.
Let us have a copy of this. That affidavit is not on record.
Oh,
Let us have a copy. Let us see what the commissioner is doing. The respondent number 1 has filed an affidavit in opposition. Ms. Thapa has submitted that in the affidavit in opposition already filed by the respondent number 1, it is mentioned that the finance department rejected the ceiling proposal on 31/3/2026, citing the remark, quote, department is requested to move aforesaid proposal in the next financial year subject to budget availability and compliance of DFPR, 2022, unquote. Etu my photo might be do photo eta copy di dibo. The husband of the petitioner, who was assigned duties of a presiding officer during Panchayat election, 2017-2018, died in an accident on 10/12/2018 while discharging Panchayat election duties. Full stop. The subject matter of this writ petition is non-disbursement of ex gratia amount of rupees 10 lakh. Full stop. From the facts pleaded, it is evident that a period of 9 years has elapsed, a period of about 7.5 years, 7 or 8, 7.5 years, more than 7.5 years have elapsed since the date of late Alauddin Ahmed on 10/12/2018. Yet, the state respondents have not disbursed the ex gratia amount of rupees 10 lakh to the widow of late Alauddin Ahmed. Para such state of affairs, suggestive of lackadaisical attitude on the part of the respondents, state respondents. Para, Mr. Whether this is justified, Mr. Gogoi? We don't know. All must speak in one voice. Mr. Gogoi. Otherwise, this time I'll ask for personal appearance to explain what kind of region is this. For 10 lakh, finance department is, you are announcing so many things, but 10 lakh is not given. Place the case on. Okay, issue notice returnable, all our respondents, issue notice returnable on immediately. 10th of August. Respondents are represented, so and so appeared, accepted, no formal notice. BUA 3, the respondents shall invariably place up-to-date instruction on the returnable date as regards sanction and release of the ex gratia amount of rupees 10 lakh. And if the said amount, ex gratia amount of rupees 10 lakh is not released, sanctioned and released by 10/8/2026, then the respondents shall invariably, without fail, make their stand on the issue in their affidavits, which are to be filed without fail on or before 10/8/2026.
Item 3.
14.
1408. Item 3.
May I please Rosip? Rosip, the petition was filed regarding the Coach Bigla Zamindari estate. Sir, the petition was filed-
Zamindari.
Yes, sir. Where the name of the petition was recorded in Khate number.
Where is Mr. Majar Bhuiya?
Yes, sir, Rosip is appearing on our court.
How many petitioners?
So one petitioner here.
He is always in installment, creating trouble for the court. The petitioner has claimed that, at present, he is in possession of a parcel of land measuring 3 kathas, 11 lesas, covered by tag number 136 within bracket old, stroke, tag number 151, stroke 973, new. At what is the village?
Page four.
Huh?
Page 4.
Page 4.
Proceed page 2, page 3.
Page 3.
Kathaldi.
Which paragraph?
Para 1. Proceed.
Village Katha. Village. Dash. Kathaldi part 3. Comma. Moja Kathaldi. Bilaki Par Revenue Circle District, Dhubri. Full stop. It is stated that the state parcel of land is a part of total areas of land measuring 34 bighas, 2 kathas, and 16 lesas. Originally under Khatiyan number 62, full stop, para. It is the case of the petitioner that the said parcel of land is a part of original Khatiyan number 62, which comprised of a total area of land measuring 34 bighas, 2 kathas, and 16 lesas. Full stop. It is stated that the Khatiyan number 62 was issued in favor of the predecessors in interest of the petitioner. Full stop. It is the further case of the petitioner that Khatiyan number 62 was issued in the name of his predecessors in interest under the Gwalpara Tenancy Act 1929, which was subsequently repealed by the Assam Land Holding within bracket adoption of relationship under the Assam Land and Revenue Regulation, 1886, in the acquired permanently settled areas, bracket close, settled estates, bracket close, Act 1974 Act for short. The total area of land under Khatiyan number 62 had, does, come under the direct ownership of the government of Assam by virtue of the Assam State Acquisition of Jamindaris Act 1951. Full stop. The petitioner's further case is that by virtue of section 4 of the subject of the 1974 Act, he as a tenant, the predecessors in interest of the petitioner, as tenants, of the he, as tenant, occupying the subject plot, has acquired the status of landholder by operation of law, and therefore he is entitled to get pattas for the subject plot on payment of revenue. Full stop. Para. The petitioner has raised an apprehension that the state respondents are claiming that the subject land has become khas and is in contemplation to evict the petitioner from the from the subject plot at any time without serving any prior notice to him. Full stop. Para. Issue notice returnable in so and so, as all the respondents are represented. Okay, you are Mr.
BJ Hajon.
PJ Hajong. Hajong,
Yes, Lordship.
okay, petitioner. And board revenue 1,
2, 3,
SS
and
Roy
2 and 3.
2 and 3. Para. The duly represented and notices are accepted by the land. Dispense with extra copies. Having regard to the apprehension raised and the projection made as regards the right of the petitioner, it is object, in the interest, in the interim and in the interest of justice, that the status quo as regards the subject plot, mentioned in paragraph to paragraph of question. Tag number so and so, question. Mentioned in paragraph above be maintained by the parties till the returnable date. List the case. There is another case along with WBC number so and so. List the case of the 4 weeks along with WBC number so and so. Number 2 quote him side.
Lordship, similar item number 5 and 6.
Wait,
382726.
5 to the parties are same. How many petitioner? 1.
1 petitioner.
The paragraph 6 of the 3 years, painless as under old DUG number 136. Old DUG number 136 to 195 and DUG number so and so new tintas. Number 62. That's what we're doing. DUG number old, DUG number new. That's it. 62 Patiana.
Item 4. Instructions first for
Yes.
That is awaited, but my lord, admittedly, my lord, there is delay, my lord, this is a order passed on 2024.
Okay, we'll issue notice.
Yes,
File your affidavit.
one.
Heard Mr. R.S. Mishra. Learned counsel for the petitioner. And Mr. B. Google, learned. But till we decide, no coercive action.
Lots.
Mr. B. Google and standing counsel finance and taxation department for all the respondents. Full stop. I've already has. Second priority challenge is made in this petition. Para. So you have relied upon the decision. You have relied upon the decision.
Lots of decisions there, madam. Just 01. Lots of decision is there. You can just 01.
We are into different issue now.
My lord, understand, madam.
Issue notice returnable on Baki Bukit. On the other case,
Yes,
we are lining up on the same day.
Yes, yes.
25th.
25th August. As Mr. Gogo has appeared, accepted notice so and so. The respondents are to bring their stand by way of affidavit on or before the returnable date. First, Mr. Mishra has submitted that the issue raised in this petition is covered by a judgment of the coordinate bench in
WBC number 946 of 2025.
on the other, Mr. Gogoi has submitted that the impugn order was passed as far back as on 30/3/2024. Impugn order was an appealable order under section 107 of the Central Goods and Services Tax Act. 2007. So, we have submitted that with no appeal filed with the within the appellate period and only the period of limitation prescribed in section 107 CGST Act is applicable, with CGST Act 2017 being a special enactment, and therefore there is no applicability of section 5 of the Limitation Act. The appeal having no appeal having been preferred within the period of limitation to file an appeal under section 107 CGST Act, the instant writ petition, apart from not being entertainable, is also not maintainable, no matter required consideration. Issue notice, so and so, so and so. Having regard to the fact that there is a decision of the court regarding summary show cause notice.
Yes, summary. No, my lord,
Right.
focus notice under section 73(1), not summary 1. Summary has been issued, my lord.
Summary. He is saying,
My lord.
I have to give a reason.
Lord, sir, Lord, sir.
Decision of the coordinate bench as regards summary of show cause notice, it is and to for this court is of the considered view that for balancing the equities, there shall not be any coercive steps on the basis of the impugn order dated 30/3/2024 till the retardable date.
My lord.
2508.
That is what is WBC? Decision of the coordinate bench in WBC number?
946 of 2025. ma'am. Item 8.
Give it a close.
The conduct council,
What conducting council?
M. Ahmed, Your Honor, the mother of the conducting council is
Because this is the third occasion now.
in Chennai, Your Honor.
Have you read the brief or not?
Yes, Your Honor.
That cannot be a ground. He is in Chennai.
Here the petitioner.
For adjournment for 3 occasions. We can allow once. Have you read the brief or not?
Yes. Yes, Your Honor.
What is the case?
The petitioner is a purchaser of plot of land on
I
cut.
agree by impugn order. Where is the impugn order? Annex 4. Yes, Mr. Gusami.
But his appeal was not disposed of.
Huh?
Appeal is page 45.
Page
45.
45. Appeal against rejection of so. Then get the instruction.
Yes, sir.
That's all.
Yes. That,
Otherwise, we'll allow him, dispose of the petition. Hard. Mr.
A high.
A.
High.
High. You are the A high. Your name is only appearing. How can you say that somebody else is in Chennai in treatment?
The name
Your
of-
name is only appearing.
The name of the A. Muhammad is not.
That
showing.
his name is not appearing in the cause list.
Something is wrong here.
We don't know. We rectify that. If somebody's name is not appearing in the cause list. I thought that you were somebody else than other than a high. Ms. Bordoloi, and Bordoloi, revenue 1, 2. Mr. N. Goswami. Learn it.
3, 4, 5.
Junior Government Advocate Assam for the respond number 3, 4, and 5. Full stop. Para, where is the impugn order? 24/10/2025. The petitioner, the case of the petitioner is that petitioner, my brief is that on 8/10/2025, the petitioner submitted an application online for the notified public service, quote, mutation after deed registration. By an order dated 24/10/2025, the designated public servant, within bracket, circle officer, circle officer, Kolgasia Revenue Circle, District Borpeta, within bracket, respond number 5, rejected the said application. Post up thereafter, the petitioner preferred an appeal against the rejection order before the respond number 4 on 5/12/2025. Post up. Para stating that the appellate authority, who is obligated to dispose of the appeal in terms of section 8 within bracket 2 within bracket small a of the Assam Right to Public Services Act, 2012, as amended, has not disposed of the appeal which was filed, which is stated to have been filed as far back as on 5/12/2025. Post up. Mr. Goswami, learn it. Junior Government Advocate, appearing for the respond number 3 and 4, is to obtain instruction as regards the status of the appeal filed by the petitioner on present status of the appeal filed by the petitioner on 5/12/2025. Is your case? Short forward. Mr. Goswami lays the case on after 7 days.
10th August.
You need a copy?
Yes.
Mr. So-and-so, then also for the petitioner, shall furnish a copy,
Soft copy.
a soft copy of the petition to Mr. Goswami by tomorrow, so as to enable Mr. Goswami to take appropriate necessary steps from his end for obtaining the instruction.
10/08.
9.
Yes. Hmm. Petitioners, how many? 6.
6, my lord. Okay. As per notification of November 2022, they applied, my lord,
Hmm.
but their petitions were rejected.
Hmm.
And along with the petition, my lord, as per
Your petitions were rejected
rejected, my lord. So
for conversion or for settlement.
for settlement. My lord, what happened? We applied as per 2019 land policy, my lord, along with annexing the 2G by the revenue. Now government, what did, my lord, government was pleased to reject our petition and land was converted to Medipatta, my lord, in the name of respondent number 5 APDCL. On the recommendation of the subdivisional level and advisory committee.
That was in April 2025.
Yes, ma'am. So your lordship, now my prayer at page 18, my lord.
Page 18.
18 to 20.
So there is eviction also.
Lord, eviction, my lord. And eviction I have challenged in this petition, my lord, to show cause as to why the impugned eviction shall not be declared illegal. And also, my lord, that respondent number 6 may be directed to modify their recommendation in respect of the scheduled land, my lord, because there is vast area. So our land could be excluded from the recommendation. And another prayer before your lordship is this, that Pata issued in the name of APDCL, my lord, in respect of scheduled land may be cancelled by the respondent number 3. Because, my lord, large area, my lord, we have some portion of land. APDCL can get it, but our portion should be given to us. We are landless person, my lord. Our possession, my lord, amounting to 1 to 7 bigha, my lord. Ultimately, if it is average taken, my lord, it is 15 bighas only. 15 bighas of land out of this 200 or like this bigha, my lord, given to the APDC. Like this land has been given to APDC.
Yes, Mr. But will you notice? Heart, Mr. M.A.
I have an interim prayer also, my lord, that may be considered, because, my lord, we are evicted, no doubt. But after eviction, my lord, as we do not have any alternative land, my lord, we are staying there.
After eviction,
We are.
how can you come back again and repossess the land? So
Your
that
lordship,
will not make it
my lord,
legal.
your lordship will consider that after eviction, my lord, they exercise power, respondent exercise power under Rule 18
of the Assam Land Revenue Regulation. We have been evicted. After eviction, my lord, land has been given patta to APDCL. Now the dispute in between, my
No,
lord,
when the patta was given,
my lord, patta, your lordship would be pleased to see.
when
Subs-
patta was issued.
Subsequently, my lord, after eviction, my lord, page 46 onwards.
The date. Tell me the date.
My lord, the approval, yes,
Approval is not patta.
no, my lord.
Patta.
Page 46.
Date, Mr. Usami.
Eviction, my lord, it is on 29/12/2025.
20,
9,
2025. Right.
yes, my lord.
And when the eviction?
Eviction was on, that I am giving the date,
Date you have mentioned?
my lord. That I have mentioned. Evicted on my lord. 8/6.
So on 8/6/2025, it was government land.
It was government land.
Then
Evicted, no, my
and
lord.
thereafter,
Your
then
lord.
how can it be?
Just 1 minute.
That is what I have read the order.
My lord.
I have
just-
read the order of
My
the
lord,
coordinate bench,
your
Mr. I have read and I tried to
Lord,
understand.
your-
I wanted to know the date. That is
Your,
not
your lordship.
hard, Mr.
Just,
M.S. Sheikh.
no, my lord, your lordship would be pleased to see.
Hard, Mr.
1 minute, my lord. Let me clear my position. My lord, patta is issued as on today, my lord. If your lordship consider that on 8.
We will not examine that issue. Your
But-
statement
but
is
regarding my
your statement in paragraph 6 is sufficient.
my lord, that's all right, my lord. Let me submit, my lord. Your lordship will pass the order, no problem. Your lordship considered the aspect that what is the position of the land on 8/6 we were evicted. Now, my lord, we entered into the land. Subsequently, land has been given patta. Now, your lordship, whether the government has a power to exercise power under section
We will examine that.
Rule 18 again, my lord.
We will
So,
examine
my lord,
that.
to that aspect, my lord, your lordship coordinate
Well,
bench.
I have read, Mr. Sheikh,
My lord,
after I took the time
my lord,
to read
my lord,
paragraph page 62, 63, 64.
my lord.
And thereafter I have asked you
My
the
lord,
question, the date
now your
of
lordship,
your.
now your lordship coordinate bench given.
I have
petition.
seen Mr. Sheikh. I have seen Mr. Sheikh. This is an interim order while issuing notice.
My lord.
I may not agree. This is not binding on me.
No, my
It
lord,
is not a
I'm-
judgment.
I'm not saying that your
Heard
lordship is
Mr.
binding.
M.S. Sheikh.
My lord,
Counsel for
please,
petition.
para 11, my lord.
Please,
page
Mr.
63.
Sheikh, be quiet.
My lord,
I have heard you enough.
my lord.
In a similar repetition, I have heard you already.
My lord, for your lordship's information, I went to the division
Come
bench.
back with the order.
My lord, your
Come back.
lordship, my lord, there is a point to be considered by your lordship. Because,
We'll
my
keep
lord,
it.
I am in patta land now. How the government can evict us again? We are in patta land.
So you have a license
No, my lord,
after being evicted. Mr. Sheikh, your eviction on 8/6/2025
yes,
is a matter to be examined whether it was following due
My lord.
procedure of law.
my lord,
Right?
yes,
8/6/2025.
my lord.
Right?
In December.
Now tell me that has to be justified.
Your lordship will consider another point. On 29/12/2025.
Show me when is the that you have gone in appeal or is the judgment of the division bench. So
My lord,
let us-
certified copy I have not got, my lord. Your lordship would be
if that
pleased
is
to consider.
vacant, my
No, my lord,
order.
I'm traveling your lordship.
Mr.
because I have a
Sheikh,
point, my
if
lord.
I have declined the interim order and the
Decline.
division
Your-
bench
my
has
lord, status
allowed
quo-
has
your
passed any
lordship-
order of
my
interim
lord,
order.
My lord, your lordship,
I am asking you, Mr. Sheikh,
my lord.
in a almost similar repetition.
Yes.
I had declined interim prayer.
Interim means, my lord, your lordship
I had
refused status quo.
Yeah, right.
Yes, ma'am.
Please,
My lord.
I did not pass any interim order.
My lord.
Then you had gone for appeal,
Yes, my lord.
right?
My lord.
Whether the division bench had passed an interim order
My lord, division bench,
When it is to be listed? The order has been uploaded.
my lord, that is vehicle number.
Waste time after some time. Come back with the order.
My lord,
Item 10.
Yes.
As per the last court order, I am directed to furnish yes, lordship. The letter has been issued to the petitioner.
And he received or not?
Yet, we don't know lordship, but we have issued the letter to him, lordship, for his attendance. On 13 March, he has applied for the same, and on 16 March, the department has issued the same, lordship.
Did you appear?
No.
First is that violation of principles of natural justice. Did you appear? Because you have said that there was no opportunity granted.
My lord, there is no endorsement.
Huh?
What endorsement?
No, he has got it from office. Now you have to respond that he has said you were issued a notice.
My lord, as per my specific instructions, my lord,
Where is the statement?
statement, my lord, in 5.
Whether this 16/3/2026 has been mentioned anywhere?
Yes, my lord. Here I have mentioned. my lord,
16/3/2026. Where have you stated that no opportunity was granted? Because that day you were making submissions.
Yes, my lord.
Ah.
Page number 29 that I have applied, my lord.
29.
Page number 29, and thereafter in my.
Allow me to personally present, page 29, paragraph 12,
Yes, my lord.
right? Allow me to be present personally
Yes.
when you made this representation or reply.
Yes, my lord.
Now, they say that on 16/3, because that was on 13/3,
Yes, my lord.
then this notice was issued on 16/3.
See, my lord. In between, my lord, there is a small development also. Here specifically, I have pleaded, my lord, that I have not given an opportunity to be present physically, my lord. As per letter goes, my lord. In between, I have also approached this honorable court for extension of time, my lord.
that has been disposed of.
This has been disposed of with an order that I was allowed, my lord. I have the order copy with me, my lord. That was disposed on 0703, my lord. So
It is mentioned here in the
no,
petition.
it's not, it is only for the extension of time, my lord.
Yes, Lord.
But you should have mentioned,
Yes, Lord.
you should have mentioned.
Only on the,
So cause notice, it will be served. Would be served. Equity be balanced. Time is given. Direct exercise find all not before 13/3.
till 13/3, he was allowed
Huh.
to. And on
Then
13th
thereafter, a notice was issued. According to them. Generally, officials cannot say an incorrect fact. Now, question is whether it is served or not.
this is my learned friend can apprise.
No, it is you who knows the truth. Court does not know the truth. It is the counsels
As per my.
on instruction received from client
Yes, my lord, as per.
are aware of the real facts.
As far as my instruction, my lord,
Well, issue notice,
and
but no further coercive step on the basis of the order shall be taken.
I'm deeply obliged, my lord.
We'll examine. He is a man of what?
Will be stayed
68, huh?
Indirectly, if your lordship passes an order that no coercive action, because action will not be taken.
No, we'll
from the
not
social
stay this
justice.
order. We'll not stay this order.
Lordship,
But if you want to visit him,
because administration will have to take the action, whatever action they will take, lordship. Because SLSC's part is over, lordship.
now who's the
Administration part. lordship.
administration
District
part?
administration.
My lord,
Please.
my lord is
Please.
issuing notice, my
No,
lord.
let us see.
Besides place 41, my lord, assuming, my lord, I have received, my lord, there was no occasion for me not to attend the hearing, my lord, because what I have specifically pleaded, prayed for, my lord. And then thereafter, page 41, my lord, it's the non-speaking. order.
Whether what is the notification? What is the notification kind of thing? What is Madhuri Patil?
Madhuri Patil, yes, my lord.
Lordship, at present I don't have.
Because this is finding of fact,
Yes, lordship.
and that is a fact-finding body.
99.
Because on that day you referred to a particular paragraph.
Lordship.
5 and 6, 13, 5 and 6, my lord.
Hmm?
13,
Page, paragraph 13.
13, specifically 5 and 6, my lord. 5,
On that-
affinity,
On that day, my learned friend had referred to page 25, paragraph 12. Then
Page, paragraph.
page
this
29,
is in regards. to
paragraph
my-
No, no,
12.
tell paragraph. You say about paragraph.
Paragraph 12, page 29, lordship. That opportunity of hearing should be given to him.
Paragraph.
I'm
Just a
sorry.
minute, I remember, Mr. Tapadar, please,
I'm sorry, my lord.
please. Which paragraph out of paragraph 13?
5 and 6, my lord.
Inquiry report was forwarded to you? Inquiry report was forwarded. Superintendent of Police. CID submitted an inquiry report, page 24, show cause notice. That inquiry report was forwarded to you.
As per my specific instruction, my lord, I am repeating, I have not received the CID report, my lord. And to that extent, my lord, my footwear will be to see once again page 25 in the first paragraph that I have replying to the show cause notice. I have written that forwarding letter of Special Superintendent of Police CID was given to me, my lord. As far as my instruction goes, when
I'd like to submit that a bunch.
say secret report may not be given, my lord. That was the verbal instruction that I have received from my client, my lord.
Have you mentioned, Mr. Kapada?
My lord.
Come to page 24.
Yes, my lord.
Last line.
Yes,
A copy of the inquiry report submitted by the inquiry officer
Is an-
please,
I'm sorry.
is enclosed herewith for your ready reference. This is a clear statement. Now, where is the rebuttal of the clear statement? Where is the rebuttal in your reply? Clear rebuttal. You said, Mister, be serious about what you make. 66 seats, along with the above referred notice dated 5/2/2026, one seat, and a forwarding of special senior superintendent of police Ulubari. Where have you stated that the inquiry report is not furnished? You acknowledge receipt of 66 number of pages, along with 2 other pages. Mr. I know your status. You are a doctor. Where have you made, you are an educated person. Where have you made the clear statement that I did not receive the copy of the inquiry report? Don't play with the words. Where is your clear statement? That I did not receive a copy of the inquiry report? It is, letter is very short. You are a knowledgeable person. You can very well understand the contents of the letter at page 24. Show cause notice. They said clearly a report is enclosed. Now, in reply, you say a bunch of 66 pages. Is it a bunch? Place the 66 pages before the court, because we are into principles of natural justice. Madhuri Patil says report is to be furnished. Place, have you annexed those 66? Place those 66 pages of bunch of papers, whether it is a report or not. The court will examine on the first day itself. Right? Whether as an educated person, a doctor, and he was also
Former chairman.
great constitutional body. So, according to your understanding, if that bunch of 66 pages is not report, let the court examine. Place those. Place those
My expert.
for at least perusal of the court.
My expert prayer will be, my lord. Besides,
We are not issuing notice. I'm asking you to place it. 66 number of seats, bunch of 66.
Whether that,
Hard, Mr.
whether that include the inquiry report that.
We'll see. 66 pages, definitely marked. Place those 66. A.S. Tapadar, R.M. Das, 1, 2, 3, and Goswami, 4 and 5. Mr. Das, Lion Standing Council, Department of Social Welfare and Empowerment, in reference to the order dated 24/7/2026, has submitted placed a copy of an office letter bearing number so and so dated 16/3/2026, issued under the hand of the chairman, SLSC and Special Secretary to the Government of Assam, Department of Social Justice and Empowerment, Gauhati. So the letter is found addressed to the petitioner for his appearance before the SLSC at 12:30 p.m. on 23/3/2026. Post of para. Mr. Tapadar has submitted that he will obtain instruction as to whether the petitioner has received the letter dated 16/3/2026 and has also undertaken to produce the punch of quote undertaken to produce 66 sheets along with 66 sheets unquote, along with the notice dated forwarded, along with the notice dated 5/2/2026 and a copy of the forwarding of the Special Senior Superintendent of Police, CID, Assam, Ulibari, Gauhati on the next date of listing. Lays the case. Monday.
Against this letter, Lordship, on 5/2/26, he has approached the Honorable High Court for staying, and the court has rejected the prayer.
Let us see bunch of 66 seats along with a forwarding report. Forwarding reports, I am forwarding here with my report.
Lordship,
That 66 might be a report or may not be a report.
Right.
Let us see how because he is a knowledgeable person,
yes,
right? Chairman of the APSC, so he can term it as not a report, then we'll go by his understanding.
Lordship.
Yes.
The prisoner actually he sold a second-hand computer parts through online market. To complain.
Okay. Bank freezing. Heart. Mr. S.K. Singh. Learned counsel for the S. Singh. Learned counsel for the petitioner. Mr. B.J. Tolder, learned senior counsel. Listed by Mr. P.K. Mehdi, learned junior government advocate, Assam, for the response number 1, 2. 1 and 2. First up. In this petition, the petitioner stated that the petitioner is presently a student of Chandigarh University, Gurgaon, Haryana. Post up. The petitioner, when an offer to sell used computer parts relating to a projector was made to the website of Facebook within bracket marketplace, comma, the responding number 7, responding to the offer, comma, accepted the offer at rupees 27,000. After showing the operational condition of the computer system, the petitioner delivered the same to the respondent number 7 at Gauhati post office. That it is the case of the petitioner that the computer system got damaged due to short circuit, due to fault attributable to the respondent number 7 post office, yet, comma, despite his fault, comma, the respondent number 7 asked for refund for rupees 27,000 post office. The petitioner, comma, in reply, comma, request for return of the computer systems so sold by him to find out about the actual defect for rectification. Post of the goods, the goods goods for sort. The goods were returned to a petitioner, and the petitioner found that the goods were damaged to the goods were damaged and non-repairable, and therefore the petitioner expressed his inability to refund the amount of rupees 27,000. Para. The petitioner, the respondent number 7, had thereafter made a complaint online alleging EPI fraud, and a complaint was registered by acknowledgement number 204102500128897 on 8/10/2025. Due to registration of such complaint alleging cyber fraud, comma, a general diary entry number 8 was registered on 15/11/2025 at Cyber Police Station, Gauhati, and as per instruction, placed, comma, the entire amount, comma, an amount of rupees 27,000 was placed on hold. An amount of rupees 27,000 on the bank account of the bank account number so and so, as a paragraph 5, maintained by the petitioner at HDFC Bank. Which branch? Paragraph, respond number? No. Chandigarh University Campus Branch, within bracket, respond number 5. Full stop. Para. By an order dated 5/10/2025, passed by the Court of Learned Subdivisional Judicial Magistrate, within bracket S-2, Kamrup Metro, Gauhati. On the basis of a prayer made by the investigating officer in connection with Cyber Police Station General Diary entry number 8, dated 5/15/11/2025, comma, the Court of Learned Subdivisional Judicial Magistrate S. Roman 2, Kamrup Metro, Gauhati, passed an order dated 5/12/2025. Where is that order?
Page 22. Annex 3.
allow the investigating officer to approach the concerned bank to initiate the refund process of rupees 27,000 to the account of the respondent number 7 and to submit a compliance report thereafter. Full stop. However, instead of placing a lien on rupees 27,000, the entire bank account of the petitioner has been blocked at the instruction of the respondent number 2. Hence the repetition. Issue notice for returnable on so exotic. As Mr. Medi, appeared accepted notice on behalf of the respondent number 1, 2, and 3. No formal notice, extra copies. Steps upon respondent number 3. Oh, sorry, 1 and 2. Respondent number 3 to 7 by speed post within 2 working days from today. The respondent bank authorities shall bring their stand by way of affidavit on or before the returnable date. First of the respondent bank authorities shall also, the respondent investigating respondent number 2 and the respondent number and the respondent bank authorities shall assign the reason as to why the entire bank account of the petitioner, the bank account of the petitioner has been entirely kept on hold.
I know there is interim prayer also regarding issuing of NOC for the mobile number. That mobile number is also blocked.
First off, the petitioner has also submitted, has also stated that why that has been placed. At the instruction of the respondent number 2, the petitioner's mobile number 875-000-6089 has also been blocked. Who has instructed? Huh?
It is on the basis of respondent number 2.
2. But you said in the interim prayer, respondent number 3. Is it not? Shortly bigger 3 weeks. Prayer for interim order will be considered on the returnable date.
24th August, 2408. Item 12.
Yes, Mr. Mishra.
May it please respect challenge and notification, my lord, number 56, my lord.
Summary.
No, my lord, here notification is challenge, my lord, whereby the time limit for passing the order was extended, my lord. Coordinate bench has interfered with the notification.
What is the decision of the Supreme Court?
It is pending, my lord.
It's
Pending. Still pending, my lord.
Pending.
Pending, my lord.
Heard Mr. R.S. Mishra, learned counsel for the petition. So we'd go by the coordinate bench
Lordship.
as on date.
Or, my lord, let it be pending because there is a series pending, my lord. After this, my lord, new development in the Supreme Court.
So we'll issue notice
Lordship, Lordship.
and we'll pass an interim order
Lordship.
because we have to go by the coordinate bench order
Yes, yes.
since it is not upturned.
Lordship.
And Mr. B. Gogoi, learned standing counsel, Finance and Taxation Department for all the response.
One is the
Okay.
union, my lord.
Okay, K. Jain.
One.
K. Jain, learned counsel on behalf of Mr. S.C. Kayal, learned special counsel and learned senior counsel and special counsel CGST. CGST for the response number 2 and 3. And Mr. B. Gogoi, learned standing counsel, Finance and Taxation Department for the response number 4, 5, and 6. Any CGC? Very, yes, Miss A. Sharma, learned counsel on behalf of Mr. B. Chakraborty, learned Central Government Counsel for the response number 1. Post up. It is stated that Mr. Gogoi has submitted that the issue, involved in writ petition is presently pending before the Honorable Supreme Court. Both Mr. Jain and Mr. Issue notice returnable on so and so. As so and so appeared accepted, no problem. Yes. In view of the judgment and order dated 19/9/2024 passed in a batch of writ petition including WPC number 3585/2024 by coordinating bench of this court, it is ordered, in the interim, that the operation of the, there shall not be any coercive steps against the petitioner pursuant to the impugn order dated 30/04/2024, whereby a demand has been raised for rupees 1,72,005,671 till the returnable date.
2nd September 0209. Item 13. Similar, my lord. Financially different, rest are same, my lord. Financially is different, my lord.
Okay.
And order date is different, my lord.
Just for that, if you have made the correct synopsis, I am putting it only.
Yes, my lord, correct.
So that for further reference. Okay. Interim order likhibo. Impugn order 26/5/2024.
28, my lord. 28.
Okay, 28/8/2024. Demand is 4,47,04,24. Till the returnable date.
14.
14 and 20, my lord, same. On the last occasion, your lordship, these two obtain instruction, as per instruction, my lord. Adjoining Dag, my lord, from same market area.
Let us see the previous order.
Adjoining.
GMA Chaudhary. Petitioner, single petitioner?
Yes.
Mr. C. Borua.
1 and 5.
Learned standing counsel.
And HADC.
NHID seal for the respondent number 1 and 5. Mr. A. Aforesaid ji, revenue. 2, H.K. Hazarika, Junior Government Advocate, Assam for the respondent number 3 and 4. PWD. Oh, and 7 also. And any standing counsel, name reflected.
Same.
Is Mr. Gogoi there? Somewhere nearby?
I'll inform you.
B. Gogoi. Standing counsel, PWD for the respondent number
My lord, 6.
6. Para. What kind of property?
My lord, commercial, my lord, land and building.
Which paragraph?
Paragraph 14.
Paragraph?
And my lord,
No description. The petitioner's main grievance is that the commercial cum residential structure, grocery shop, boundary wall, water system, and well ring standing on the plot of land which has been brought under the purview of the acquisition process under the provisions of the National Highways Act 1956, have not been assessed by the acquiring authority and the requiring authority. First, the petitioner has stated that the petitioner is not aware whether the competent authority land acquisition, respondent number 5, has determined the compensation for the plot of land and those structures standing on the plot of land as per the provisions of section 3G within bracket 1 of the NH Act. First of para. Mr. Hazarika, Land Junior Government Advocate, appearing for the respondent number. Kala is 4. And Mr. Borua, Land Standing Counsel, NHIDCL, appearing for the respondent number 5. Have sought for 1 week's time to apprise the court on the aforementioned aspects, including whether any determination is made under section 3G1 or not, and if any such determination is made, to place a copy of the award so made. List the case on 7/8/2026. And 8. The only copy of the award.
Yes.
We'll see. If that has been assessed, end of the matter.
I'm thinking whether I'll be available or not. I'll be available.
Next one is
Item 20, ma'am.
what kind of structure?
Same building, my lord. Paragraph 10.
Paragraph 15, page 50 not. It likha ase commercial cum residential structure, grocery shop, boundary wall, water system, and well ring. Same. Parties are same. Other two matters are also listed on 7/8.
Yes, ma'am. Obvious.
Total 4.
Item 15.
Yesterday there was something, some GST cancellation matter. Yours?
No, ma'am.
I issued notice.
That was different.
No, that has been disposed of. That is for different region, not regarding time barred.
Yes.
Cause of action.
Yes.
That is regarding cause of action. But here is a case, issue of
They preferred appeal.
limitation.
Lordship, the preferred appeal was dismissed on the ground of limitation.
Okay.
Now they have to prefer appeal under section 112.
Otherwise, Lordship will see the order at page 17.
No, question is, I have
yes.
already, in your case right now today.
Not today, my lord. Sorry, the 25th.
Ah,
Yes,
today.
different one, not GST, different one. 25th of August, my lord.
Yes, my lord. With different issue.
Mr. B. Gogoi
Yes,
was
yes, yes,
appearing.
yes, yes,
I
because-
passed a detailed order, his submission.
So DRC, it was DRC 01, my lord.
Same issue
Same issue, 25th of August.
regarding limitation.
25th of August.
Which one? Item number?
Item number 4, my lord.
Item number 4.
4, my lord. 4.
And what is the date?
Date of order, my lord.
No, no. Returnable date.
25th of August. 25th.
Okay. Heard. Mr. R.S. Mishra and counsel for the petitioner. Now, Mr. Mishra, your counsel who is appearing regularly in GST matter,
My lord.
there is a notification.
My lord.
In every GST matter, both union, state,
My lord.
GST authorities are to be made parties.
Yes, ma'am.
Otherwise,
Yes, ma'am.
appeal will be dismissed in limine,
Yes, ma'am.
allowing you to, I will not allow to file amended cross title
Yes, my lord.
after the notification.
Yes,
You are one who is regularly appearing.
my lord.
Mr. Kyle, for one? No. Where is Mr. Central Government? Okay. You are Central Government Council? Okay. Mr. H. Sharma. H. Das, learned Central Government Council for the respondent number 1. Mr. S. C. Kayal, learned Senior Counsel and Special Counsel CGST, estate by Mr. K. Jain, learned Counsel for the respondent number 2, 3, and 4. Para. The petitioners. Registration under the Central Goods and Services Tax Act 2017 came to be cancelled by an order dated 16/8/2023 passed by the proper officer, purportedly due to non-filing of return for a continuous period of 6 months in terms of section 39 of the CGST Act. Full stop. In this writ petition, the said order of cancellation dated 16/8/2023 has been assailed on the ground that the impugn order dated 16/8/2023 was without any reason. Full stop. It is stated that when the petitioner, after the order dated 16/8/2023, attempted to file a revocation application, the same was disallowed as the period of filing, as the period of limitation for filing the revocation application was already over. Full stop. The petitioner had thereafter preferred an appeal against the order dated 16/8/2023 under section 107 CGST Act, and the said appeal also came to be dismissed by an order dated
10/4/2026, my lord.
10/4/2026
26, my lord. Recent issue. 26, my lord.
as time barred. Full stop. Hence the present petition. Full stop. Mr. Kyle, learned senior counsel, and so, appearing for the respondent number 2, 3, and 4, has submitted that the order dated 16/8/2000, the appeal, an order passed in appeal under section 107 CGST Act is appealable under section 112 of the CGST Act. And since the order dated, appeal order 10/4/2026 is an appealable order, and the period of limitation there is period of limitation still available to the petitioner. The petitioner, instead of preferring an appeal under section 112 CGST Act, has approached this court under Article 226 of the Constitution of India. Hence, full stop, this petition is not to be entertained. So appeal is available.
My lord, Since my appeal order was dismissed on limitation, my lord, perhaps I will not get remedy there. That is the reason. My appeal was dismissed on limitation, my lord. So I have an apprehension I will, if difficult to get order there, my lord.
So if that order, I have to set aside that order,
My lord. And even
appellate order,
since my dismissal on
because
limitation,
that order would not merge with the original order.
yes, my lord. It would not.
Law is settled. Now where is that order?
Page 17, my lord.
Appellate order.
So that is page 36. 36.
Because that original order has been enveloped by the appellate order now.
My lord.
Unless this appellate order is set aside,
My lord.
we cannot go into that.
That is there, my lord.
Now, if the reason is as per the law,
Fine.
where is the scope for interference?
That is I have challenged.
It is admitted position.
That's I have challenged both this order, my lord.
So, under Article 226, that order.
Yes.
Okay, issue notice returnable on 25/8, but fate is known,
My lord.
almost
My lord.
90% known, unless you come up with better
My lord.
submission.
Or-
25/8,
or
2026.
Lordship may allow me to, with the liberty to approach the appellate authority, my lord. Second appellate authority, Lordship permits them.
Okay,
With the
section
liberty.
14 I can apply after dismissal.
My lord. Then it can be
You
done.
intend to appeal under 112.
I can try my luck there then. I can try my luck there then, Lordship.
Yes, better. In view of the obtaining fact situation, and since an appellate remedy is available to the petitioner, Mr. Mishra, learned counsel for the petitioner, has fairly submitted that, and the petitioner is not pressing this application as an appellate remedy under section 112 is available, and the period of limitation for filing such an appeal is
31st July 2026.
31st July. Otherwise, 10/4/2026 means under 112, perhaps three months,
3 months.
May, June, July, or 4 months.
But otherwise, Lordship, there is a notification.
It is all right, extended up to
31st July.
initially 30th June.
Yes, sir.
Now it is 31st July.
Okay.
And there is another notification, something by the chairman.
Yes, sir.
Online?
Yes, he can.
Online?
Online, man.
Okay. File it online.
Man.
And period of limitation to file such an appeal is available up to 31st July 2026. The writ petition is therefore not entertained, reserving the liberty to the petitioner to avail appropriate appellate remedy under the law.
Much.
16.
Your Lordship, I will, item number 16, kindly pass over the matter for the day.
Mandama shall not be issued on settlement terms of such a right.
My Lordship, the senior counsel is not well.
Right. Are you aware of the case?
No.
Since there is no interim order, we'll issue notice. There is no prayer for interim order.
Yes.
We'll issue notice. Yes, your name, please.
Jay Das.
J. Das, learned counsel for the petitioner. Ms. Bordolo, you are for 1 and 2. 1 and 2. Director of Land Acquisition and Bordolo, learned Standing Councillor, Revenue and Disaster Management Department for the respondent number 1 and 2, and Mr. H.K. Hazarika, learned Junior Government Advocate Assam for the respondent number 3 and 4, first of it is the case of the petitioner that the petitioners are in long, continuous and uninterrupted possession of a plot of land measuring 4 kathas and 5 lesas, covered by Dag number so-and-so, para 2, and under Khatian number so-and-so in lot number 4 at Revenue Village, Suklatari, Moja, Bilakipara Revenue Circle, District Dhubri. So, according to the petitioner, the possession of the subject plot is from a date in the pre-independence period. Post op. The petitioner has stated, petitioners have stated that the predecessors in the names of the predecessors in interest of the petitioners were recorded as recognized occupants in the concerned Khotian. Post op. However, without any notice, the subject plot has been converted into government khas land, despite possession of the subject plot. Despite the petitioner's possession of the subject plot. Post op. The petitioners have approached this court by the present petition, seeking inter alia a direction for settlement of the subject plot in their favor. Issue notice returnable on Swens. As Ms. Bordole, 1 and 2, Hajorika, 3 and 4, no formal notice, extra copies into working list.
7 September 0709. Item 17.
Yes.
Worship, in this case, what has happened is the petitioners had purchased 2 plots of land. Thereafter, their names were mutated. And then due to some administrative thing, their lands were declared to be covered under the Selling Act. But however, thereafter, the authorities themselves came to a finding that this was erroneously.
Where is that?
Yeah, page 41, Your Lordship. This is the type copy, Your Lordship.
Okay. Where is the operative part?
Operative part, your last 2 lines, 42. So the plots of land mistakenly recorded under selling is released from the urban.
Part Mr. A. Vishwas, learned counsel for the petitioners. Mr. J. Revenue A. Authorised Revenue 1. J. Hendrik
2 and 3.
2 and 3. Post op. Para. So your case has been registered. Your application has been registered.
Applications are registered, but no steps are taken by the authorities to even.
It is before district commissioner.
Yes, Lord.
Yes, Mr.
Let me take a step.
You take instruction.
Yes.
Right, that will expedite the issue.
Yes, yes.
Petitioners are primarily aggrieved by non-disposal of their application dated 21/6/2025, which has been registered and numbered as case number E-1135003. And the said case is presently pending before the respondent number 2.
Yes.
Post op. It is para. It is the petitioners have averred that by an order dated 26/7/2000,
Yes.
comma, in an order, passed by the respondent number 2 in ULC case number 129/1995. The respondent number 2 had himself observed that during the settlement process of sealing case number 129/76.
Yes, sir.
76. A plot of land measuring 1 biga
2 bigas means 2 adjacent lands.
or 2 plots of land,
2 plots of 1 biga each.
comma 1 biga each,
Yes.
comma covered by Dag number Roman 1, Dag number 958 under patta number 32 and or both under same patta.
Both are same.
Dag number 958 and 985.
948 units.
In the order
And 950.
958 and 985.
Yes.
Correct?
949 units.
Then your type copy is wrong.
No, your lordship, it is that 958 and 949.
Page 41.
Page 41, your lordship.
Fourth paragraph.
First, second, third, fourth paragraph.
Okay.
Let
Dag
us-
number 949
949
and dag
before that
number 958, comma, originally under patta number 32,
Yes.
comma, were made government sealing lane mistakenly. Right?
Yes, your lordship.
Full stop. By the order dated 27/6/2000, comma, the respondent number 3 directed for release of the said 2 plots of land from the purview of the urban sealing case. Full stop. By the application dated 21/6/2025, the petitioner have sought for carrying out necessary correction in the revenue records in terms of the order dated in respect of the said 2 plots of land in terms of the order dated 26/7/2000. Full stop. As case number so and so has not been brought to its finality till date, the petitions are before this court by the present writ petition. Para Mr. As case number E-so and so is stated to be pending since 21/6/2025. Mr. Hendrik, learned so and so, is to obtain instruction regarding the present status of case number so and so. Para, as sought for by Mr. Hendrik, lays the case on after next Wednesday. Or yes, Mr. Hendrik. When? 7th of August?
10th, Lordship.
10th of August. Yes. You need any copy?
I will give it.
Okay, a copy of this writ petition along with the annexure is to be furnished by the learned counsel for the petitioner to Mr. Hendrik during the course of the day to enable Mr. Hendrik to obtain the necessary instruction.
Highly obliged.
Daily list, item 18.
Yes.
May it please your lordship. My lord, the petitioners before your lordship are in possession of cash land, my lord, for about 50 years. So, my lord, after notification of 11/11/2022, they went to the office of the collector of Dhubri district, my lord, to file online application as provided under land policy of 2019. But that Dhubri district, my lord, on development is there, that no online application is accepted after certain period. Thereafter, the petitioners on offline, my lord, file their application for settlement of the land, and that those applications are pending before the authority. Now, what happened, my lord? The authority during pendency of the representations, they want to evict us. Hence, this petition before your lordship, that till disposal of our representation pending before the deputy collector of the district, my lord, we should not be evicted. And that representation may be disposed of.
Yes.
They are occupying the government land.
Heard Mr. M.A. Sheikh, Learning Counsel for the petitioners, Mr. N. Bordole, and Standing Counsel, Revenue and Disaster Management Department for the respondent number 1. Mr. J. Hendik, Learned Junior Government Advocate for the respondent number 2 and 3. The petitioners, 5 in number, have stated that they are in occupation. The family of the petitioners, since the time of their predecessors in interest, are in long and continuous occupation of the plots of land, mentioned in Schedule A to E of the writ petition, since the for about 15 years, close to 50 years. And the respondent authorities have been collecting Tozi Bahira revenue against such possession of the plots of land coast of Para. The petitioners have stated that in terms of a notification dated 11/11/2022, providing for eligible citizens to apply for settlement of government cost and ceiling surplus land. The petitioners had submitted their applications. Try to submit their applications online as per the prescribed mode, but those applications, online applications, were not accepted. Post of thereafter, the petitioner, having no alternative, filed representations before the respondent number 2 on 36/2026. Post of it is the contention of the petitioner that the representations of the petitioners are not yet considered and disposed of. Quader claim for settlement of government costs and ceiling surplus in their favor as indigenous landless person. Post of Mr. Sheikh, Learning Counsel for the petitioners, has submitted that when the representations are yet to be disposed of, the respondent authorities are contemplating to evict the petitioners from the plots of land mentioned as Schedule A to E of the writ petition. First of para, the matter of required consideration, issue notice returnable on so and so as Mr. Bordole 1, Hendik 2 and 3, no formal notice, extra copies, in view of the projection made by the land, in view of the projections made by the petitioners regarding their long and continuous occupation on the plots of land mentioned in Schedule A to E, and regarding in view of apprehension expressed by the petitioners, it is observed that there shall not be there shall not be if any eviction process is initiated by the respondent authorities, they say must be in strict adherence to the procedure laid down by a division bench of this court in Salakuddin versus State of Assam and others report, 2024, 4 GLT 857. That is full stop, strict adherence. Now, it is further observed that pendency of the writ petition shall not be pendency of the writ petition shall not be a bar for the respondent authorities to consider the representation submitted by the petitioner for settlement of Schedule A to Schedule plots of land mentioned as Schedule A to Schedule E in the writ petition by the respondent authorities on their own merits and in accordance with law, more particularly, the land policy of section 2019.
Let this petition order disposing our representation may be communicated to us.
Pendency of the writ petition, that is settlement. Is there any provision in the notification
No.
for communication? Then I'll definitely.
That is not.
Just a minute.
That is not there.
If the representations are disposed of, the decision taken thereon are to be communicated to the petitioners immediately thereafter.
And even then, they are saying that they can process through the online. The online, some documents is required. That document, if my line of friend has submitted on or not.
Representations, they have failed to.
It is available in the Dhubri district. Online process is there. Online, Pathakandi.
I would have Mr. Ms. Bordole and Ms. Hendik. Mr. Hendik have submitted that the facility of submitting online applications for the notified public service, quote unquote, settlement of government khas and seedling surplus land is available in Dhubri district. And therefore, the petitioner ought to have filed their applications for such notified public service online.
2808, 28th August. Item 19.
Lordship, the petitioner is an original pattada who is protected under section 10 of the Land Regulation 1886. And subsequently, he have some constructed houses over his property there. And an eviction notice has been issued over his patta land, alleging that somebody other is occupying in illegal position. Under Rule 165, 160, Your Lordship.
Yes. Who is this Arvina Sultana?
And the Gauhati of that village conducted an inquiry and somebody informed that Arvina Sultana has been sold of the property.
There is no person like Arvina Sultana.
There exists a person, she was been called upon by the authorities. Then she has submitted some deed of agreement for sale, which is neither registered, nothing. It's just a rough draft and which cannot be executed as per the.
So you have not handed over possession to any Arvina Sultana?
No.
Where have you stated?
Page 20. Page 9, para 13, your lordship.
Page 9, para 30. Do you have entered into any agreement?
No, your lordship, I have annexer 5, panel, your lordship. It's a rough draft which cannot be executed under.
No, no, but I have asked you whether
No,
you
no,
have
no, no, no.
executed any
No,
agreement
no, lordship.
in favor of Arbina Sultana.
No, your lordship.
Lordship,
Page?
46.
Page,
46.
where is that agreement?
Annexer 5, page 46.
Page 46.
Both the parties have been signed.
Registered,
It's not registered, your lordship.
notarized.
Not notarized, your lordship. Just a stamp paper. It has been signed over a stamp
No,
paper.
page 46, stamp paper only.
Yes, yes. Stamp.
Agreement or memorandum of an agreement. This is, you are Mr.
I'm the original.
Sanjur Ali.
I'm the original pattada, your lordship. And Arbina Sultana has been issued an eviction notice alleging that she's
Where is that agreement?
agreement is
Okay.
page number 46, your lordship.
Okay. So you have executed this agreement.
Lordship is
It appears to be an agreement for sale of land.
yes, lordship. Sale has not yet been this cannot be executed under chapter 10, your lordship. And the property has not yet been in possession. As per rule 165, I have to be in possession, your lordship. I am not in the possession. Arbina Sultana is not in possession of the LS property.
You are not Arbina Sultana.
I am the petitioner, your
So
lordship.
why you are making submission on behalf of Mr. Mr. I could understand
Yes, sir.
what is in your mind. I am not expressing.
Yes, your lordship.
It has come out of your own.
Yes, your lordship.
Why this person is not there? We'll implead. We'll implead this Arbina Sultana.
Okay.
Why you have not made party respondent? File an impleadment application.
Obliged.
Otherwise, the notice, if it is in the name of Arbina and you are the landowner, then that notice will be non-est in law. Make her a party. Heard Mr. Jade Khalid. Yes, Mr. What do you want to say? Mr. J. Henry Clanet Jr. को मैं advocate Assam for the response number 1, 3, 4 and 5. Aforesaid revenue 2. Full stop. The petitioner has stated that he is the original patadar of a plot of land measuring 1 katha covered by dag number 529 under KP Patta number 210, situated at village Khena Alibari Mauja Dokhinrani, Polakbari Revenue Circle, District Kamrup, Rural Assam, subject plot. Full stop. Before the notification dated 27/10/1950, whereby South Kamrup tribal block was notified. The family of the petitioners was the owner of the subject plot. Full stop. The petitioner has approached this court to assail by the present petition, writ petition, to assail an eviction notice dated 16/7/2026 issued by the respondent number 5 in respect of the subject lot stating that the individual named in the notice is allegedly in possession of the subject plot, which is in a tribal belt, and in the notice, the name of one Arbina Sultana has been mentioned as the person in possession of the subject plot. Post op. It is a case of the petitioner that since the petitioner is the owner of the subject plot, any notice to any other person like Arbina Sultana, other than the petitioner, to vacate the subject plot would be invalid and inoperative. First of para Mr. Henrik and Mr. Aforesaid have submitted that since the notice, eviction notice dated 16/7/2026 has been issued in the name of Arbina Sultana, Arbina Sultana is a necessary party in the instant writ proceeding. Post op. They have further submitted that from Annexure 5 to the writ petition, it is evident that the petitioner had entered into an agreement for sale of land, sale of the subject plot to Arbina Sultana, subject to obtaining sale permission from the competent authority. And after sale permission, the subject plot is supposed to be transferred by execution of a sale deed. First of all, the matter would require consideration. Issue notice, returnable on so and so. As so and so appeared, accepted, no formal notice, extra copies. Para. Any eviction notice for the subject plot is to be addressed to the owner of the subject plot, since it is canvassed by the petitioner that he is the owner of the subject plot, and no notice, eviction notice, has been issued to the petition, but only to one, the intending purchaser, Arbina Sultana. It is ordered in the interim that there shall not be no eviction process in respect of the subject plot shall be carried out till the returnable date. Mr. Khalid, Learned Counsel for the petitioner, has submitted that he will file appropriate pleading for imprisonment of Arbina Khatun as a party respondent in the present writ proceeding for adjudication, for proper and effective adjudication of the issues raised in this writ petition within a period of 2 weeks.
Lordship, one similar matter, supplementary 55.
Let us see. Which one?
55.
Sultana, Arbina Sultana. Item?
Okay. Here also in this case, the original patadar has not received any notice. Here, his tenant has received notice alleging that they are in illegal possession, Your Lordship.
They are parties.
They are not parties, Your Lordship. They are tenants, Your Lordship. We have annexed all the tenants agreement, Your Lordship.
Tenancy agreement.
Yes, Your Lordship. 49 page, annexure 3 page 14.
3 plots of land, paragraph 3 does covered by.
4 plots, Your Lordship.
Here, paragraph 3 is 3 only. Paragraph 3.
Schedule of the land, 4 persons have received notice, Your Lordship.
No, in paragraph 3, you say that you are the owner of these 3 properties.
Yes, here the person receiving the eviction notice are staying here in this scheduled property. Paragraph 8, Your Lordship, is stated the in details.
Paragraph?
8, Your Lordship. Paragraph 8, 9, 10. And 12, Your Lordship.
Where is the notice? Three notices. Comma dated 16/7/2026.
Okay. Four notices, Your Lordship. One common notice is there.
Where is the common notice?
Page 66, annexure 8, Your Lordship. Is the type copy?
I don't go by type copy.
Vernacular is Lordship, page 71.
You are not making them parties. Who are they in the 3 notices? There are many names, 3 names each. Which one? There are 3 notices,
Yes, sir.
right?
Yes.
Which one? Court will pick up.
No.
Who will pick up? Which one is the tenant?
Sahinul Islam, Your Lordship.
Because you are not making them parties deliberately.
Annex all the notices, Your Lordship. No,
You annex all the notices. There are many names.
from page 88, Your Lordship, these are the individual notices. 82, 88.
This is not individual notice. There are 3 persons each.
Putuvali is there, Your Lordship.
Which one? Page?
Page 84, Your Lordship.
73.
Yes, Your Lordship.
Which one?
Page 84, Your Lordship. Putuvali.
Kutupalli is also in page 73.
Yes. Sahinul Islam. Yes, Nasiruddin Khan.
Yes, Nasiruddin.
84 years Nasiruddin Khan. Then Sahinul.
Page 75.
Yes, Your Lordship. No, 84 is the notice.
Come pay.
75. 75. Nasiruddin Putuvali, Sahinul Islam. Yes, Your Lordship.
Come on.
Yes. No. Sahinul.
Nasiruddin Khan.
Lordship, they are sharing ducks in separate parts. So notice has been issued as part of ducks, Your Lordship. Person is the same, Your Lordship.
No, who are your tenants?
My tenant is Sahinul Islam, Nasiruddin Khan, Putubali.
No, 18, paragraph 3. These are the plots of land?
Yes, Your Lordship.
Paragraph 3.
Yes.
The impugn notices, comma dated 16/7/2026. shall not be no eviction process. No, the impugn notices, comma dated eviction notice 16, the operation on the impugn notices, comma dated 16/7/2026, comma shall not be made effective in respect of the 3 plots of land, aforementioned 3 plots of land, in respect of which the petitioner has claimed ownership till the returnable date.
28 August.
Baki implement of the necessary tenants with whom the petitioner had executed rental agreement, implement.
Obliged. 2808. 21.
Lordship, in this matter, Lordship, we have challenged the removal order of district commissioner on the ground that no reasonable opportunity has been given, Lordship. And the order was passed on 7/7/2026, but served upon the petitioner only on 22/7/2026. I have specifically mentioned it.
Panchayat Act.
Panchayat Act.
Disqualification.
Disqualification. Lordship.
Under section
Lordship, rule 62(4) is the power conferred.
62(4). Constitution rules.
Constitution rules.
No. So where is Panchayat? Yes, do you have the latest Panchayat Act?
This one. Dada.
Sixty
2(4). Lordship, sir.
62. Page 26. 62. 62.
4, Lordship. 4 is there, Lordship. For B and C, Lordship, they have exercised.
You are Gaon Panchayat.
I am Gaon Panchayat member and subsequently elected as president, Lordship.
What is the main provision? Section 111.
11 2F, Lordship. 2F, child marriage, Lordship.
Is there any specific provision that an opportunity is to be afforded?
No, Lordship. Only in the rule that on establishment of facts, Lordship.
Yes, Mr. Ms.
And-
Thapa. Case of the petitioner is that no notice, no opportunity of being heard.
Notice में बोलो Instruction district.
If you have not afforded any opportunity
Lordship.
or a copy of the inquiry report, even if it is not explicit,
Lordship.
it is held to be ingrained before any adverse order is passed. So far, this Annexure D is concerned,
Lordship.
I have
not-
reservation.
Lordship, I am not placing that part, Lordship. That's why. I am aware, Lordship, and Lordship's order went up to.
Yes,
Super-
my
I will-
judgment has been upheld by the division bench and
And
by
to
the
the-
Supreme Court.
Yes, I have.
So
that is why-
this
that-
judgment is par incuriam.
I'm not, Lordship. That's why I'm not hesitating, Lordship. That part. I have this natural justice part and another.
Yes, why? We'll stay.
Lordship.
We'll
Lordship.
stay.
Lordship.
Heard Mr. M.K. Hussain, learned counsel for the petitioner. P. Thapa, learned counsel on behalf of Mr. S. Dutta, learned standing counsel, Panchayat and Rural Development Department for the response number 1, 3, 4,
6 and 7.
6 and 7, and Mr. H.K. Hazurika, learned junior government advocate Assam for the response number 2 and 5. Poster. In the Panchayat general election of 2025, the petitioner got elected as a ward member from ward number 04 of Maheri Par, Gaon Panchayat, under Panchayat, District Nagaon, post up. By, where is the MP order?
Page 138. Annexure F, last page.
By an order dated 7/7/2026, the respondent number 2 in exercise of powers conferred by section 111 within bracket 2 within bracket small f of the Assam Panchayat Act, read with rule 62 within bracket 4 of the Assam Panchayat within bracket Constitution rules 1995 as amended, has adjudged the petitioner as a disqualified person to continue as a ward member of the Gaon Panchayat and has removed the petitioner from the office of the ward member of the Gaon Panchayat with immediate effect. Post up. In the MP order, in the order dated 7/7/2026, the respondent number 2 has observed that the seat shall be treated as vacant with immediate effect. Full stop. Para. Mr. Hussain, learned counsel, appearing for the petitioner, has submitted that the procedure for removal to adjust an elected ward member of Gaon Panchayat has been laid down in section 111 of the Assam Panchayat Act, more particularly, section 2 thereof, and in rule 62 of the Assam Panchayat Constitution rules 1995 as amended, more particularly, para. The respondent number 2, while holding an inquiry, is required to call, is required examining the matter and on establishment of facts can remove a ward member like the petitioner. First up, it is his submission that though not explicitly explicitly mentioned, comma, it is implicit, it is ingrained that any adverse order, any order which is adverse to a person can only be passed by following the principle of natural justice, principles of natural justice, and on opportunity is to be afforded to that concerned person before any adverse decision. So in the instant case, the petition has not been afforded any opportunity, prior opportunity of being heard, and therefore the impugn order dated 7/7/2026 is in violation of the principles of natural justice. You should notice returnable on so and so, as so and so has appeared, accepted, no formal notice, extra copies. In the basis of any complaint,
Nothing reflected in the lordship order, lordship. That's why we have not,
no complaint.
nothing reflected. lordship.
Hmm?
Inquiry, self-inquiry.
Okay. Regarding information of minor morals. Okay. It is not in the impugn order.
Not regarding complaint, nothing reflected, lordship.
Okay. Name of the complaint is not there.
Not there.
Okay. এনেকে লিখক, okay, it is there. So you entered into marital relationship when you were minor.
Minor, yes.
That is the case.
There is a case prior to.
Okay, the ground on which the petitioner has been disqualified is that the petitioner entered into marital relationship when he did not even attain the age of majority.
Marriageable list, lordship.
In view of the assertion made that no prior opportunity of being heard was afforded to the petitioner prior to passing of the order dated 7/7/2026. It is ordered, in the interim, that the operation of the order dated so and so shall remain in abeyance till the return.
2nd September 0209. Item 22.
Wait, please, my lord. Petitioner herein is challenging two eviction notices, my lord.
What is your story now?
Yes, my lord. The petitioner's paternal
Same.
grandfather.
No,
If I may,
that's, item number 55 is his vendor. So there is some confusion. I just checked. There is notice
55.
was issued. Just lordship was issued.
No, two cases already been moved. That
Yes.
is why I'm.
In
Who are you?
this is
Sonam Begum. You are landowner.
I am a resident of the tribal belt. There are documents to prove that I've been a resident ever since prior to the notification whereby the area was.
And who is your landowner?
Landowner is one Bolendro Chandra Thakuria. I have an agreement.
Oh,
with-
Bolendro.
Bolendro. Now Bolendro says
That I
he's
am.
Bolendro is made a party.
no
No, we're not.
Same.
difficulty because he says his notices were issued in the name of tenant.
Bolendro is not recognizing you.
No, there is an agreement to sell my lot. My agreement is there.
The sale permission.
No,
not
in
granted.
the other petition, Bolendro was the petitioner, is the petitioner.
I'm not aware of that.
He has recognized 3 tenants. This Sonam Begum is not his tenant.
Here he has enclosed an agreement for sale,
Yes, my lord.
but no NOC was not issued to him. Therefore, the sale could not be executed.
NOC apparently, my lord, the authorities have.
So Bolendro is a party or not?
Bolendro is not a party.
The necessary part.
Bolendro is not aggrieved.
He is not a- My lords, he is.
For the eviction
But
notice
the
issued to you,
notices have been issued to me.
Bolendro is agreed with 3 persons. That I entered into tenancy agreement with 3 persons in respect of my land in tribal belt. Bolendro is not aggrieved in any manner with you. Bolendro has come to the court. Bolendro is not recognizing you.
Now, that would perhaps require a determination. My lords, the eviction notices otherwise, as far as I'm concerned, they have been addressed to me, my lords. The hearing that was preceded by the eviction notices, I was present during the hearing, and all those notices were
Same
also addressed to me.
story. Bolendro is not impleading them. He is tenants. Now you are not impleading Bolendro. Interesting case.
I'm not a tenant otherwise, my lord, there is an
Huh?
agreement to sale.
Interesting cases.
Till today, Bolendro is the owner.
Well, then the authorities.
So
concerned-
Bolendro is a necessary party here.
My lords, but I'll have to take steps now.
Where is your agreement for sale
Yes.
of land?
Yes, my lords. My lords, when-
This in the teeth of chapter 10
Chapter 10, my lords,
is outrightly illegal.
my lords, I would try and satisfy lordships on that.
Because even if Bolendro is in possession of plots of land in chapter 10 land,
Right.
right, there is complete bar for him to transfer the land
To-
by way of sale to categories of persons who do not fall in section 162 or 163.
Yes, 160.
So this is outrightly an illegal agreement.
The
When
regulation,
Bolendro is not here, Bolendro is not concerned with you.
that transfer of
Your locus is on the basis of an illegal agreement.
for the agreement, my lords, subject to what lordship holds, would be subject to regulation 164 to be the first proviso. For people who have been are residents of those tribal areas, even if they don't belong to the protected categories or the tribals.
So,
they-
let us see Sonom then. Where is your forefather? How old are you?
Yes.
If you go into that aspect, you
Well,
are
that-
23 years.
20.
Who are your forefathers?
Yes, I'll show that. The first-
Because I myself is in possession of plot of land in tribal.
Same goes for me.
Some other tribal.
My
But-
fathers as well.
I have record of 150 years. Mr. Bhunia is also. So I have records of 150 years of my forefather. You are 23 years. Show us.
Forefathers, my lords, as far as the petitioner hearing is concerned, page 21.
But you have to make Bolendro a party.
That is what happened. Sir, if he's challenging, I was not.
You are nobody. Let us see chapter. Chapter 10. Which provision?
Yes. 164, my lord.
164.
Regulation 164 2 B first proviso, my lords.
164.
2 B, the first proviso, my lords.
64. 2.
First proviso.
Except with the previous permission of the deputy commissioner. Read 164A.
Proviso, perhaps.
Proviso will not stand because of the non-obstante clause in section 164A, which has come by way of an amendment with presidential assent.
Yes. May I then, my lords,
Hmm.
place this judgment of the Honorable Division Bench, 2003.
Janajati.
No, my lord, this is Dina, not Brahmo.
Brahmo will not be applicable for you.
My lords, I am a resident of the tribal belt. My lords, there are documents to prove that.
Brahmo falls in the category
Well, what my submission before this honorable court, my lord, says, well, I am admittedly not, I do not belong to the protected class, but I am an inhabitant or a
Yes,
resident
when
of
the
the.
other cases are, Mr. Bharatji, returnable debt. I heard Mr. B. Chowdhury, counsel for the petitioner. A. Bharatji, Revenue 1, HK Hazarika 234. The petitioner has been served with an eviction notice dated 16/7/2026.
Two eviction notices.
Huh?
Two eviction
Two?
notices for 2 drugs.
Oh, you are in possession of 2 drugs?
Yes.
Which are?
555 and 550.
Where is that?
Yes, ma'am. The notices, my lord.
Page.
Yes, 49. The first notice.
2 eviction notices. For areas of land, Roman 1, 10 lessors covered by tag number 555 and under KP Pata number 164. Two eviction notices, both dated 16/7/2026 for areas of land 1 measuring 10 lessors covered by tag number 555 under KP Pata number 164 and 2 1 Katha covered by tag number 556 under KP Pata number 36, at village, revenue village, Khena Ali Bari, Moja, Dokhin Rani, Polakbari, Revenue Circle, Kamrup, rural or metro?
Will be rural.
Kamrup district.
F1 would be 14 lessons.
Huh?
Page 58. Under
Oh,
that
sorry,
number-
14 less. 14 less. 14 less. Posto. By which? Because by the eviction notice says the petitioners, the petitioner has been directed to vacate herself from the subject plots and to remove all structure standing thereon within a period of 15 days from the date of receipt of the notice. Because the petitioner has stated that the petitioner came into possession of the subject plots after entering into an agreement registered,
Not registered.
an agreement for sale of the subject plots with one Bolendra Chandra Thakuria on 1/11/2025.
711.
7/11/2025.
Yes.
First off, the petitioner has stated that for the at an exit consideration, first off, and a copy of the deed of agreement for sale has been annexed to the writ petition as Annexure 5, wherein it is mentioned that the Sri Bolendra Chandra Thakuria, as the proposed seller, had already received an amount of rupees 3,89,000 as advance out of the total agreed consideration for sale at rupees 4,39,000, and thereafter the petitioner, who is the proposed purchaser, has been handed over possession of the subject lots. Meaning thereby, the petitioner is in possession of the subject lots after the deed of agreement for sale of land on 7/11/2025. Full stop. The petitioner has contended that the petitioner is only in possession of the subject lots, and the respondent number, circle officer, respondent number,
Circle officer is the respondent number 4.
ought to have served the eviction notice to the land owner of the subject lots, and full stop, without service of the eviction notices, comma, the eviction notice is invalid and inoperative of law and cannot be acted upon. The matter would require consideration. Mr. So-and-so, it আগৰটো যে implement কৰা নাই, Bolendo so-and-so, Hajorika and Proceed. Mr. Chaudhuri has submitted that he will file appropriate pleadings for implement of the landowner of the subject plots within 2 weeks' time, issue notice returnable on so-and-so, as it is averred that I got to Mr. interim order. Same day.
2808.
Silo.
Supplementary list, item 50.
Oh, that bank guarantee.
I have gone through it, my. I have gone through it. It will be difficult because there are two. We got the Reserve Bank of India. Reserve Bank of India was a circular, master circular. We got it. Now, Reserve Bank of India, my lord, it has given to different banks, but power has been given to the banks. But there is also a provision where there can be an extension after 10 years. But it depends on the bank to bank. Now, this policy of my learned friend's bank is up to 10 years. Up to 10 years, number one, man. Now, there is what will be fine that there is a letter recently by yesterday. It has been written by the bank to my learned friend beneficiaries client. That's a NIPCO. They have said Powergate said that now it is with us. They said that the period is completed. Contract is completed.
Oh, good enough.
Now that's what I
for these 2 bank guarantees.
Yes, 8 bank guarantees. 8 bank. And they said that we make a request to the beneficiary saying that don't extend this, don't pray for extension of this bank guarantee. Now this is one. We'll bring it by an affidavit. Number 2.
Initially, firstly, say in the first writ petition page, serial number 50.
Yes.
In respect of how many bank guarantees, this Bank of Baroda, right?
2.
2 bank guarantees. They said that 10 years period have maturity period is about to expire.
Malo, there are 2 writ petitions.
No, first one by one.
Yes, no, I'm going for
In
one.
item 50,
Yes.
how many bank guarantees of
2 bank guarantees. 2 bank guarantees.
they sought 100% cash credit?
No. That has been invoked. That has been invoked. In first writ petition, there are 5 guarantees. Out of 5 guarantees, 3 has been extended. 2 has not been extended and it has been only invoked.
Oh, invoked.
That's why we want.
There is no question of stay.
No, there is that is only a notice will go. Whether it is an entitlement for refund or not, that's a part different. Notice will go in the first case, my friend.
Okay, let me issue notice.
Yes. In the first case.
Let us
go by one.
Issue notice.
Yes.
Wait, in 50, item number 50, first case, bank guarantees have been invoked.
Yes, invoked.
They have received the proceed.
They have received the proceed.
There is no question of
No.
consideration of interim.
There is no question of.
Heard Mr. D. Das, learned senior counsel. Assisted by Mr. K. Talukdar, learned counsel for the petitioner. Mr. M. Sharma, learned counsel for the respondent number 2, 3, 4, and 6. Mr. N. Khera, learned counsel for the respondent number 3 within bracket virtual mode for the respondent number 5, and Mr. A. Parvej, learned counsel for the respondent number 5. Mr. S. Chakraborty, learned counsel, settled government counsel for the respondent number 1. First of The petition, in this petition, the petition has questioned the decision taken by the respondent number 2 bank, right?
Yes.
On 36/2026, whereby the respondent number 2 bank has refused to extend the validity of two bank guarantees bearing number so and so dated 2/8/2016 and bearing number so and so dated 4/11/2026. 16, I think 16 perhaps. Mr. Taludar, page 30. Prayer. Page 30.
Page 30, para 37, page 22.
Page 30, prayer 1. A. It should be 4/11/2016,
411,
not 26.
480.
One is 2/8/2016, one is 4/11/2016, respectively. The petitioner has also assailed the action taken on the part taken by the respondent number 2 bank, whereby it has adjusted an amount of rupees 2,76,40,620 by invoking which amount was received by the petitioner towards income tax refund. Okay. Issue notice returnable on so and so. As Mr. So and so appeared, no formal notice, extra copies within 2 working days from today. The respondents are to bring their file their responses on or before the returnable date.
2nd
Yes.
December 0209.
51.
Yes. My learned friend has given
The big bunch he has given.
given the policy.
I have not gone through.
I have seen it.
Page number 69 and 7.
Page
69. You could have marked it.
Your Lordship, on that day, I have also not read it out.
Where is the master circular?
Master circular here.
Bengali, which clause? Which clause?
Which one, my?
That
In the bank circular.
we're into 10 years.
10 years. The lordship will find.
It is on page 69, which part? Which part? Top part or second part?
Your Lordship, page number 70, top part.
Top part.
My lord, your lordship will first see the master circular of RBI.
Yes. Were authorized to permit issuance of master circular, yes.
See the master circular 2.1, 2.1.3. 2.1.3. No bank guarantees should normally have a maturity of more than 10 years. However, where bank extend long-term loan for period longer than 10 years for various projects, it has been decided to allow bank to also issue guarantees for period beyond 10 years. While issuing guarantees, banks are advised to take into account the impact of very long duration guarantees on their asset liability management. Further, bank may evolve a policy on the issuance of guarantee beyond 10 years as considered appropriate with the approval of their board of directors. This is banks.
Individual.
Yes.
Now
Now
this
they
is
have taken this policy and they said that our policy.
this is policy.
Yes. It
Now
is
page 69, which policy?
70, Your Lordship,
page 69.
and 70.
Which part?
69, bottom of 69.
Normally a bank guarantee.
Normally a bank guarantee, your lordship will 69. Bullet point is there. Normally, last bullet point. Normally a bank guarantee with maturity period exceeding 5 years should not be issued. Any guarantee with maturity period exceeding 5 years up to 10 years, which is not backed by 100% cash margin, individual counter guarantee of another bank may be issued as follows.
Meaning nothing regarding beyond 10 years.
Yeah, 10 years. But these depend upon bank to bank.
No.
They can,
If you read
yes,
any guarantee, these are, I think, by board of director.
board of directors.
Any guarantee with maturity period exceeding 5 years and up to
Yeah.
10 years, which is not backed by 100% cash margin, indemnity or counter guarantee of another bank may be issued.
Yes.
But it is silent about
No,
beyond 10 years.
Next page.
Next.
Page 70 kind.
Sanctioning authority can approve
70.
issuance of bank guarantee with limit exceeding
5 years, but up to 10 years. Subject to adherence to
following.
should be linked to the business of the borrower. Again, 100% cash margin or the bank
Oh.
issued again indemnity.
second one.
Second one.
Then next one is also similar.
Yes.
Shall have power to allow issuance of bank guarantee with a maturity of more than 10 years
Which is
Which is
not backed by 100%.
on a case-to-case basis.
Taking into account the adverse impact.
More than 10 years.
You are already into the red.
I'm sorry.
You are already into the red. So,
What I know, my
because the policy,
my lord will can't go against a decision.
this is a
Or a
policy
policy,
dish.
Number one. Number two, what I am saying, that now the bank, please see that letter. The letter will have. Second letter. Where is the letter?
Now, in this second case, how many bank guarantees are contemplated to be not extended?
My lord will please
This
see.
only, Your
এখন
Lordship.
আছে।
This Bank of Baroda. Then
No.
Indian Bank has already extended.
No, your page 105.
Yes, sir.
Please see one letter of the bank.
How many of them are not, how many of them are beyond 10 years?
All.
All.
8 bank guarantee.
All.
Please see the letter of the bank. Yesterday we received. এখন পাইছো না? I don't know.
The below mentioned, these are
It is addressed to Pargate. Bank of East.
this is a letter from whom?
From the bank.
Bank.
Bank of Baroda to the Pargate, the beneficiary. With reference to trail, the below mentioned are issued 10 years. Guidelines same cannot be renewed to extend 100%. Inform borrower come in not in a position deposit. Cash margin, hence we request a good or to consider for non-extension of a business contractor is on the verge of completion.
Company means you.
Yes.
Is not in a position to deposit 100% case margin in the form of so and so. And we request your good officer to consider for non-extension of above PC as the contract is on the verge of completion.
Now I can tell one thing before your lordship. They have a retention money by the beneficiary 55 crores with them. 55 crores. I'll file an additional affidavit, let it come tomorrow. It has to be part of record. That what is the period? Completion. If I completed 100%, I completed my particular instruction for my client is 100% completed. All. So that is why there is no problem with them. They cannot, that's why the bank requested them, don't pray for extension.
Mr. Khera, take a call.
My lord.
Whether to encase the bank guarantee or not, if the contract is completed. I am not into it. Court is not concerned with it. Firstly, bank guarantee is your contract with a bank.
My lord.
Right, the court has no business or Mr. Das has no business. But since he is saying that petitioner has a business with you regarding execution of contract, and which according to petitioner is almost completed or 100% completed. So decision lies on you to encase or not to encase and to satisfy yourself with the retention money.
55 crores.
My lord, we'll have to see the hunger that the contract has in its terms.
It is up to you whether to encase or not to encase. Few days are still available, up to 1/8 for 2 bank guarantees, and for other 7 it is 13/8.
My lord, if this matter can come up tomorrow, I'll also seek my adequate instruction.
Yes, tomorrow we'll bring it. Tomorrow.
Okay.
Let it be tomorrow, we'll bring it an additional affidavit also.
If they think that if it is there within their prudence that they do not invoke, it is well good for the petitioner. Okay, নাম কিটা লিখিব? S. Chakraborty, 1. Huh?
But I don't understand one thing, my lord. I just want to place it before this court. We'll bring it by additional affidavit. We brought this bank guarantees, all the bank guarantees before the court by an additional affidavit. And if you see the bank guarantees, what are the terms and conditions of bank guarantees?
These are performance bank guarantees.
Yes. Now it's, if you see at case 135 of one of the bank guarantees, they say how it should be guided. It is not by way of the policy that has been given, policy that they have made. It is by guided by the guarantee is subject to uniform rules for demand guarantees ICC publication. That is number 458.
But Mr. Das, if you go by
banking regulation.
No, RBI circular.
No, that's correct.
If you go by the clause, I think if you go by
1.3.
the B, clause B.
Clause B.
A statutory directive issued by the Reserve Bank in exercise of powers conferred by Banking Regulation Act. Though it is named circular, it is, right, if you go to the RBI Bank and Banking Regulation Act, it is basically a direction. Now, subject to some policy decision.
Correct.
This policy decision, ICC is who? ICC means what?
Indian Chamber International Chamber of
That is a guidelines, that is not enforceable.
But
This is enforceable.
Yes.
Under the Banking Regulation and RBI Act. So that is not enforceable. If it goes by binding direction of RBI, you can't help it. And if they would not have taken any board or director policy decision, then the situation would have been something, some leeway here and there. But here it is 100%.
My lord, that point is difficult.
100%
That's what
cash.
I'm saying. It is difficult. Because it is a policy decision taken by bank to bank. One of the lead bank, their lead bank given 20 years. Their bank is at 10 years. So policy.
Mr. Khera is coming up with up-to-date instruction tomorrow. Let us have it.
Tomorrow, my lord, we'll also build.
Okay.
I mean,
Or Friday.
my lord,
Friday
if
is.
it
Friday is the 31st.
I have some difficulty if it is tomorrow, man.
Okay. Mr. Das has submitted that an additional affidavit to bring what?
The records about the subsequent the correspondence
Okay.
by the bank to the beneficiary.
Bringing the subsequent correspondences made by the parties on record. List the case tomorrow. In the motion column, the RBI master circular dated 1/7/2011. Okay, no, like it is same.
There is a subsequent 1/4/25. There is subsequent master circular. It is the same clause.
Okay, I'm not recording it.
Yes.
It is already there. And any change?
No, your lordship.
One sentence, but it's the same.
Tomorrow.
Item 52.
Obliged, my lord.
Yes. Something related to obesity trial.
Yes, Lordship. As per last court order, I was to produce the under what stage, Lordship, apart from the order which I
You
have,
have become very active nowadays. This
because of the scolding I have received from your.
state level scrutiny committee.
Yes,
Cases are coming up.
Lordship, apart from that, one poem was there. Poem has been issued where your serial number 7, if your Lordship kindly.
Father identification certificate issued by authorized caste tribe organization. You want to mean that
Yes, Lordship.
B,
Two conditions are there.
second condition.
Yes, second condition, Lordship. Since the petitioner has failed to fulfill the first.
But it is either.
No, since,
Whether your father is.
no,
My father is a one, but he has not taken a caste certificate.
Oh.
But I have given my
If your father had, then second condition would not have been required.
But
yes,
your lordship, there is two things I want to point.
Just a minute, let me read. Now, what is this identification certificate?
identification certificate is a certificate which are being identified by that group, because for scheduled caste community, some organizations were being entrusted by the government. Nowadays, what happened, Lordship, as per
Please
my,
to authorize and countersign identification certificate issued by the authorized caste stroke tribe organization. This is general circular for all SC, ST, OBC, MOBC.
MOBC.
Now, this was subject matter of the PIL.
PI, there the tribal.
No, there is 22 also.
Yes. The tribal sangha itself was given the.
No, 22, something about 22. No, 2018. Not about 22. This PIL judgment was of 2023. Okay, it is silent. So did you submit any identification certificate? No.
Lordship, here, only thing what I want to point out is that this procedure maybe isn't applicable for a person who is getting a fresh new certificate. I already have a caste certificate. Only thing I am seeking now is an online. So for online, yes, maybe whether it is a mere procedural formality or again the entire.
Yes, Mr. Das, then
Lordship,
for renewal.
renewal, Lordship, there is a bar, Lordship, if Lordship, since the petitioner father does not contain the certificate. If the petitioner's father's got the certificate, he can upload the same in the online, then easily the concerned.
Where is your original certificate?
My certificate is at page 37
And my father's younger brother certificate is also there. That is at page 52.
Now, presently, there is a special body now, Sah Janajati Jatiyo Honminani.
Yes, Lordship.
Now, this is a special body.
So I will take the recommendation if your lordship say. Only thing,
Better to,
and
because this has been changed now.
yes,
Yes, Lordship.
Page 37 is your original one.
right.
It is all Assam Adult Backward Classes Association. Now, the government of Assam has made specifically that Sah Janajati Jatiyo Honmilani will be the organization for tea garden, ex-tea garden community. If you have genuine thing, then your father and all are
They, my father's younger
then
brother.
belong to that caste, definitely. They will like.
Yes.
So what to do?
Let him approach.
It is a otherwise private body, no council is there. Otherwise, I would have directed you to implead them, get the presence of the council, directing them that when application is filed, identification certificate should be issued within this time. Now it will be very difficult. Right. Otherwise, you can make them a party by filing an impleading application. I will make them a party, will allow you to serve by dusty. If they do not come, I can issue a direction.
Yes, your lordship can also.
Which one you prefer? Otherwise, I can dispose of allowing you to file an application before that Sah Janajati for identification certificate and thereafter to submit an application online for your caste certificate.
I'll make them a party, your lordship. If your lordship, instead of the application, your lordship can observe them and I can change the memo of parties.
No, that is, it is up to you. There is no pleading. No pleading in the writ petition. Get the pleading in the IA. Then only I can, observing that I can make them party as a necessary party. Thereafter, I can issue notice and thereafter, dusty, and if they don't appear, I can issue a direction.
Yes.
That in the event any application is filed, then must be disposed of for identification certificate within a specific period of time. Heard Mr. R. Sharma, Learned Counsel for the petitioner. R.M. Das, 134. S.S. Roy, 2678. And Central Government, B. Borua, CGC for Respondent 5. Mr. Sharma has submitted that. In view of the issue raised in this writ petition, Sah Janajati Jatiyo Honminani Ahom appears to be a necessary party. And therefore, the petitioner, the writ petition be listed. And therefore, the said authority, said organization is to be impleaded as a party respondent in the present writ petition. He has therefore sought a week's time to file an interlocutory application for implement. Full stop. So when you can file? Today is Wednesday. Release the case as sought for by Mr. Sharma on next Wednesday.
0508, 5th August. Oblige. Item 53.
Yes.
The order impugned is at page 43.
Yes.
This was an appeal filed against an order which is at page 38. Passed by zonal officer under 41(6), acting as a registrar. And he appeal was filed before the registrar. Can he take up his own cause? My first question is that has to be replied.
Yes, Mr. Do you have the notification?
Well, I have the notification.
Let us have the notification.
So this is the notification. And 41(6) says it should be registered. Act
41(6).
41(6), it should be registered.
Zonal joint register.
My lord, when the 41(6).
Who has passed zonal joint register?
And my lord, in the Act 41(6) is, my lord, raised where a board fails to arrange the holding election. 41(6).
41(6).
The registrar shall convene a general meeting for appointing an officer of the cooperative society for constitution of board. So he was acting as a registrar.
Mr. Talda, do you have the original notification?
And
41.
And 41(6) says about the registrar.
Where is the power delegated? In the 41(5) is there.
My lord, 111 is also there. 111 is also there. Your lordship will find in the notification.
This is zonal joint register, right?
My lord. And 38, the order was passed by zonal joint
This 38 is under 41(6). He says specifically in the order that power delegated. Now, he says page 38. Then again page 40.
It was filed before the register itself.
Yes. Short, but pertinent. Okay, in the notification, 41(5) is not there. But in the order, he made it specific that in exercise of power delegated under 41(6).
No, in the impugn order.
Impugn order, page 38.
Page 38.
No, he says.
Page 38.
That is why I have asked you. Because we are looking at type copies. Oh no, this is original.
Original.
Oh, this is original. Then there might be, what is 41(5)?
The election of directors and delegates shall take place at the general meeting called for the purpose.
It carries no meaning otherwise.
No.
41(5) carries no meaning.
So it is 41(6).
Yes, Mr. Talukdar, it is up to you. Yes.
First submission, my lord, is this. What is their locus?
Mr. Mahmood has passed an order. Mr. Roychuri files an appeal before Mr. Mahmood. Whether Mahmood can decide the appeal? No.
This requisition is not.
That too, of an order passed about 2.5 years back. Renewed subsequently, that is a different issue.
First submission is this. What is their locus? Who are they?
Who are they? Shareholders,
Shareholders, my lord, they are not the board of directors
not required.
and not they were party in the before.
Not required. They
Not
are interested in the affairs of the
interested.
society.
But when the elections held in the year 2023, they were not there. They were the board of directors in the year 2018. So now they are on.
Now, who first filed the appeal? You.
No, appeal.
Huh?
Appeal was filed by society.
Heard. Mr. Stoller, you have to say anything. Appeal, sitting on appeal. On that point. Factual issue, no. But I will keep this in abeyance, subject to your legal submission. Apparently, it is sitting in appeal. No point otherwise this issue is to be stressed out. Because this will not revive the board of directors, only this. This has been happening, you have to address. My tentative view is that one cannot sit in appeal. Because there is provision for appeal before the state government. Heard. Mr. P.K. Roychuri, Learned Senior Counsel. Assisted by Mr. A.K. Ajad, Learned Counsel for the petitioners. Mr. S.K. Talukdar, Learned Standing Counsel Corporation Department for the respondent number 1 to 4. And Mr. M.U. Mahmood, Learned Counsel appearing on behalf of the respondent number 5 to 6. Post of para. The respondent number 2, no 3, on 6/11/2023 passed an order in exercise of power delegated to him under section 41 within bracket 6 of the Assam Cooperative Societies Act 2007, whereby the respondent number 3 had appointed one senior inspector stroke auditor of cooperative societies, O/O, the assistant registrar of cooperative societies, Silchar, as the officer on management to manage the affairs and to hold the annual general meeting stroke election of Messrs. Rangpur Cooperative Society Limited within a period of 90 days and to constitute a new managing committee stroke board of directors as per the provisions of the Assam Cooperative Societies Act, 2007. The respondent
6.
Number 6. Preferred
Is the president, chairman of the society.
an appeal under section 111 of the 2007 Act, seeking cancellation of the order dated 6/11/2023 passed by the Zonal Joint Register of Cooperative Societies, Kachar, Sribhumi, and Hailakandi, within bracket respondent number 3, by preferring an appeal on 29/12/2025. Full stop. The respondent number 2 by an appellate order dated 10/7/2026. Reinstated the managing committee stroke board of director of Messrs. Rangpur Cooperative Society Limited by interfering, setting aside or what? By setting aside the order dated 6/11/2023. Full stop. Para. When both the orders, comma, 6/11/2023 and the order dated 10/7/2026 are considered together, comma, it primarily appears that the respondent number 3 as the delegatee of the respondent number 2 had passed the order dated 6/11/2023, stating specifically that he has passed the order in exercise of powers delegated under section 41(6) of the 2007 Act. Post stop. Thus, comma, in essence, comma, the order dated 6/11/2023 is an order passed by the Registrar of Cooperative Societies, comma, Assam, that is the respondent number 2. Full stop. Privacy, comma, an authority cannot sit in appeal. A statutory authority cannot sit in appeal over its own order. Full stop. Thus, comma, it appears that the respondent number 2 by the order dated 10/7/2026 has passed the order under purportedly under section 111 by sitting in appeal over his own order, comma, although passed by his delegate, comma, dated 6/11/2023. Mr. Talukdar, Land and Standing Council Cooperation Department, has sought for a week's time to address on the legal issue raised by Mr. Rochuri and Senior Counsel for the petitioner, as sought for by Mr. Talukdar, raised the case on so-and-so. Being with regard to the observation made, privacy observation made above, the operation of the impugn order dated 10/7/2026 shall remain in abeyance till the next declaration.
That's what I have submissions. Kindly see the provision of 1111. Here, except where otherwise expressly provided, to the contrary, an appeal shall lie to the registrar from the decisions made under this act or rules framed thereunder by any government officer.
Or liquidator.
Or liquidator. So, any government officer.
Without looking at, I know,
any
the provisions.
Any government officer included.
Then 2 is review. 2 is review.
No, my lord.
Subsection 2.
Yes.
Subsection 3 is state government.
Registrar may review.
Then 4 is stay.
Yes. Now, question is this: when the
shall I discard your submission today or on the next date? Reserve your submission.
No, I wanted to submit my viewpoints on the point that
I'll not record today. I'll give you an opportunity. We are not issuing notice. We are not issuing notice. I am giving time because I am not convinced.
On his stay, I have.
With my own reasoning. Right. So I am giving you, Mr. Talukdar, time. So my observation is vulnerable,
7th August.
right?
0708.
On this day only I had the objection because the
Otherwise, I should have
petition is not
decided the
mentioned.
right petition as of now, right? Making all your submissions, but still procedural propriety.
That is there.
Otherwise, you, Mr. Talder, would go running somewhere.
And my lord, another thing is there. The order was. earlier
Mr.
order
Roy
was
Choudhury and
passed
Mr. Talder
in
have come to
violation
know.
of principle of social justice. We will argue on that point. In violation.
Now he is taking a different time. Mr. Roy Choudhury, there must be a restriction that once if council makes submission in one line, he cannot in a subsequent case make different submission. There must be restriction. Next.
So Lordship is looking into my history.
Next.
54. Item 54.
Yes. State.
What FIR has been lodged,
Lodged.
but as per the number 5, but it's not registered, investigation is going on.
Not registered, then follows 35, right?
Yes.
Okay, more order আছে, no? WBC. এখন দেখবো নি মাস তুমি পড়া।
Lordship, from December 25, the petitioners are harassed.
We have denied.
Every yesterday night also police. came.
WBC. একটা order আছে, no? BD করো। BD করো বরাবর। রোবো।
To second from the law.
এই WBC 2507/2026 BNSS console. Till 35. Which subsection? Which subsection of section 35?
3 subsection.
Heard, Mr. SP Roy. I'm giving a without notice, nothing. 35(3) notice.
Lordship, see the malified action, Lordship. From
No, we are not
December
entering into
25, Lordship.
But there must be henceforth strict compliance of section 35.
Until the register, till that FIR has not been registered, till the register,
Not registered.
it not registered, Lordship, I should not be harassed.
No, if it is not that for non-registration, if credible information has been received, a notice is to be given.
My learned friend told me that FIR was lodged on 7th of July. Today it is 29th. Lordship. Why the FIR was not
That is
registered?
their problem. They are saying in the opinion, it is a family affair. It is advisable they should resolve themselves. Anyway, we are not into it. We are not discussing. We are only on section 35. It is your family affairs. We are not including it. Heard Mr. S.P. Roy, learned counsel for the petitioners, and Mr. N. Goswami, learned junior government advocate Assam for the respond number 1 to 4.
Wonderful.
Full stop. Para. The petitioner number 1. Who is the Ulwa? Okay. Petition number 3 is a senior citizen and octogenarian.
Which number?
Comma, aged about 88 years. Octogenarian means 80 plus. And what is it called, Mr. Roy? If it is above 60 years?
Super citizen.
Super citizen, not super.
Senior
70 is septo. What is 60? Petition number 4, comma, who is the wife of the petition number 3, comma, is a senior citizen of 65 years. Full stop. The petition number 1 and the petition number 2 are the daughter and the son of the petition number 3 and petition number 4 respectively. Full stop. The petitioners are residents of a locality within the territorial jurisdiction of Bohisto Police Station, Gauhati. Full stop. But the petitioners have stated that petition number 3 and petition number 4 had another son, comma, Pawan Kumar Singh, who expired on 3/10/2025. Full stop. The petitioner number 6, sorry, the respondent number 6 is the wife, and the respondent number 7 is the daughter of late Pawan Kumar Singh. Full stop. The petitioner have canvassed that after the death of Pawan Kumar Singh, comma, the respondent number 2, say 5, and the respondent number 6 have been continuously harassing the petitioners with the sole intention of extracting money and to claim a share in the jointly owned family property of the petitioner. Full stop. The petitioners have come to know that the petitioners have approached this court stating inter alia that there have been repeated visits of police personnel from Bokhista police station to the residence of the petitioners without furnishing any information as to why the visits are being made. First off, when the petitioners ask for information regarding any complaint or stroke first information report registered against any of the petitioners, the police personnel visiting the residence of the petitioner did not disclose about any such complaint stroke FIR registered against the petitioner. Because the petitioners have thus contended that their right to personal liberty have been infringed by such unwanted visits made by police personnel from Bokhista police station. Full stop. The petitioners have stated that despite making inquiry, the petitioners have not been informed whether any complaint stroke FIR has been registered in Bokhista police station till date. Full stop. But the petitioners believe that behind such visits of police personnel, such visits of the police personnel without compliance of the procedure laid down in Bharatiya Nagorik Surakha 2023 are at the behest of the respondent number 5 and the respondent number 6. Post para. With such projection, the petition has been filed. First off, when the petition was moved on 27/7/2026, Mr. Goswami Learned, Junior Government Advocate, appearing for the state respondents, was asked to obtain instruction whether any complaint stroke FIR has been received stroke registered against the petitioners and stroke or about the reason for repeated visits of police personnel from Bokhista police station to the residence of the petitioners. Post of para. Today, Mr. Goswami has placed a letter dated 28/7/2027 received by him from the respondent number 4. As per the instruction placed in the said letter, it is respondent number 6 who has submitted a first information report on 7/7/2026 against the petition number 1 and the petition number 2, complaining inter alia that after the death of Pawan Kumar Singh, the petition number 1 and the petition number 2, together with the petition number 4, started torturing both of them, started torturing the respondent number 5 and the respondent number 6, both physically and mentally, and conspired and had entered into a conspiracy to drive them out from their matrimonial home. As a result, they had to leave the matrimonial house and had taken shelter in the parental house of the petitioner respondent number 5 on locking their room. Full stop. In the complaint, it is mentioned that when respondent number 5 and respondent 6 came to the house, to the matrimonial house on 5/7/2026, they found that the almirah, which was inside the locked room in the matrimonial house, was broken, and certain valuable items, including laptop, CDs, or the videos of marriage were missing. Better. On receipt of the said affair, the contents of the same were recorded in a general diary entry and entrusted the respondent of 5 to cause an inquiry into the allegations and to submit a report. Post the respondent of 5, the respondent of 5 had thereafter visited the residence of the petitioners and apprised the apprised the petitioner number 3 and the petitioner number 4 that there is an affair against the petitioner number 1 and the petitioner number 2. Full stop. The petitioner number 2 and the petitioner number 3 were also apprised that the allegation was leveled against the petitioner number 1 and the petitioner number 2, which appears to be a family affair among the members of the family. A preliminary inquiry was being carried out. Full stop. Para. It is in the letter dated 28/7/2026. It is further mentioned that the respondent of 5 had visited the residence of the petitioners only on 9/7/2026 and 25/7/2026, solely for the purpose of ascertaining the facts mentioned in the FIR and not for any other reason. And therefore, the allegation of harassing senior citizens cannot be leveled. Full stop. Para. Subsection 3 of Section 35 of the Bharatiya Nagorik Surakha Honita BNSS, 2023 contains a mandate to the effect that the police officer shall, in all cases where the arrest of a person is not required under subsection 1, has to issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, to appear before him or at such other place as may be specified in the notice. Full stop. As per subsection 4 of Section 35, of the BNSS where such notice is issued to any person, it shall be duty of that person to comply with the terms of the notice. Post of para. Thus, section 35(3) of the BNSS casts an obligation on the part of the police officer to issue a notice against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense, to appear before him or at such other place as may be specified in the notice. Post of para. As no notice under section 35(3) of the BNSS is stated to have been issued to any of the petitioners herein on receipt of the above information regarding the roles of the petition number 1 and the petition number 2 on the basis of the allegation made in a complaint which has been registered only as a general diary entry in Bokhista police station, the writ petition is disposed of with a direction to the respondent authorities. Respondent number 1 to 4. To the state respondents, more particularly, the respondent number 4 and 5. It is 6 and 7 day. Wife or daughter, 6 and 7. To comply with the prescription contained in section 35(3) of the BNSS, if the appearance of any of the petitioners herein are found necessary in connection with the allegations level in the complaint, if registered, finding out commission of any cognizable offense. So it is further observed that in the event such notice under section 35(3) is issued to the petitioners herein, the petitioners are to observe the amendment contained in section 35(4) of the BNSS. So if registered,
Registered lordship, if it is not registered, then the lordship petition.
which provision then? Tell me.
So until and unless the FIR is registered, I cannot file application for anticipatory bail order.
She is not registering. Why should I say? They will register again unnecessarily. Mr. Roy, you know the police. They will register unnecessarily. They will throw to the court. Even if the instruction placed by Mr. Goswami in the form of letter dated so-and-so of the respondent number 4 is kept with the case record. So if this time you come again, we'll admit it. Let us hope it stops.
Item 56.
But in this case, my senior was supposed to appear, my lord, but because of his health issue, my lord, he could not.
Who?
HRH Chaudhary, my lord.
Okay.
The case is that, my lord, the petitioner is a cooperative society, my lord. And the respondent number 6 was his secretary of this society, my lord. After joining service, my lord, several complaints were lodged against him, my lord, and eventually, my lord, an offense report was submitted, my lord, after inquiry by the Food and Civil Supplies, my lord. Then, my lord, a special meeting was convened, my lord, and he was suspended from the post, my lord. Thereafter, in annual general meeting, my lord, he was dismissed from service, my lord. Annual general meeting.
Dismissed from service. Annual general meeting.
In annual general
Resolution.
Resolution by resolution.
Approval.
Approval.
Where is that?
Approval is, my lord, it is not directly.
Which one?
My lord, page 22, page 73, my lord.
Page 62 dismissal, the resolution about dismissal.
Dismissal, my lord.
Hmm.
Then, my lord,
That was on which date?
13/9/2023.
39. Okay.
my lord.
Resolution number 15.
15, my lord.
So it was sent to,
Yes, my lord. Then your lordship will find
so
page 74, my lord.
অনুসৰি ব্যৱস্থা গ্ৰহণ কৰিব লগতে পৰৱৰ্তী সঞ্চালক মণ্ডলীৰ প্ৰস্তাৱ সহিতে জাননী জাৰি কৰি ব্যৱস্থা গ্ৰহণ কৰিব। What does it mean?
My lord.
Then
my lord.
neither here nor there.
Yes, my lord. Our case is that, my lord. That thereafter, my lord, resolution was communicated to the respondent number 6.
খাৰিজ কৰা হৈছে। When? 5/12/2023.
Yes, my lord. 5/12/2023, my lord. My lord, he said over, my lord, he did not challenge the resolution, my lord. And in the meantime, my lord,
Then another secretary appointed.
another secretary appointed initially temporarily. Then, my lord, his service was
Regularized. Then approval? Is approval?
Approval is, I have not annexed, my lord, approval, but
Any statement made?
statement
It was as per board resolution or what?
Act
non prostav morme. So this resolution has been approved.
In the resolution was taken in the annual general meeting, my lord.
Right.
Yes, my lord.
That is to be approved by
Yes,
authority.
Yes, my lord.
Whether that has been approved.
To my information, my lord, that has been approved, my lord, but though I have not annexed that document.
Have you made any statement?
In this regard, I have not made any statement.
That it is approved. Again, that will come again.
My lord,
Same issue.
My lord, my case is that, my lord.
If because 45(1) is also delegated. No. 45(1), suppose appointment of the new secretary is approved by any authority in exercise of power delegated. Again, it is an order of register. I'm just asking him. So now he again sits in appeal. After he approves, we cannot disapprove.
No, my lord, he can, subject to what your lordship say.
Because I have not understood supervisory jurisdiction.
This is what the division bench say. He can, my lord, examine the resolution also.
Resolution, if he, it is, resolution is different. Resolution approved by him under section 45(1), though not by him, by assistant registrar, is an order in essence by him only. Once he approves, then he cannot turn back and disapprove unless it is power of review. There has to be apparent. Now, that is why I'm asking
whether it is approved or not.
Otherwise, this order itself is his own order. There are a long line of decisions also on that.
That is correct.
That is why, and this is going on.
Because appeal will lie before the state government.
State government.
That is correct.
So that is why I am asking that whether this resolution, come to page 82.
82, my lord.
Resolution number 1.
82, my lord. Apnar gyan jana was.
সহপঞ্জীয়ক মহোদয়ৰ অনুমোদন সাপেক্ষে. So there was an approval to appoint this man as a permanent secretary, Mithu Ranjan Nath.
Yes.
If that is so, how can he bring back? Due procedure of survey has not been followed while relieving so and so from the post of secretary. Directed to follow. for taking action. So this appointment of Mithun Ranjan Das will remain for the time being, subject to whatever it is. Because if it is সহপঞ্জীয়কৰ অনুমোদন ক্ৰমে page 82, they are saying from temporary to permanent. Then one man has already been on the post. And this order, impugn order, has not reinstated directly.
My lord, one thing is that, well, after 2.5 years, my lord, he
That
challenged.
I know. That I have seen.
And another, my lord,
Heard
he,
Mr. A.H.M.R. Chaudhary, Learned Counsel for the petition. And Mr. S.K. Talukdar, Standing Counsel Corporation Department for the response number 1, 2, 4, and 5. Mr. S.S. Royal and Junior Government Advocate Assam for the response number 3. Closed up. This petition is what? The instant petition is prepared by the Petitioner Society is a registered a cooperative society registered under the provisions of the Assam Cooperative Societies Act 2007. The 2007 Act for short. Full stop. An order dated 22/6/2026 passed by the respondent number 2 has been assailed in this writ petition. Para. The order dated 22/6/2026 has been passed by the respondent number 2 in an appeal preferred under section 111 within bracket 1 of the 2007 Act by the respondent number 6, wherein a decision taken by the Board of Directors of the Petitioner Society in its meeting held on 30/6/2023 has been challenged. So by the said resolution stroke decision, the respondent number 6 was removed from the post of Secretary of the Petitioner Society. Post of Mr. Chaudhary, Learned Counsel appearing for the petitioner, has submitted that subsequent to a resolution taken by the Board of Directors of the Petitioner Society by resolution number 15 in its meeting held on 13/9/2023.
my lord, 13/9/2023, my lord, petitioner was removed from service. His respondent number 6 was removed.
Respondent number 6.
6.
Decision.
And,
Sorry, by resolution number 15 taken by the Board of Directors of the Petitioner Society on 13/9/2023, the respondent number 6 was removed. A decision was taken to dismiss the respondent number 6, already suspended under suspension from the post of Secretary of the Petitioner Society. Post of the minutes of the meeting of the Board of Directors of the Petitioner Society were forwarded for approval to the respondent number
5.
forwarded for approval, and the respondent number 5. had approved, had uh, decided and allowed the Petition Society to take action as per provisions of the 2007 Act and the rules. No, not rules. And bylaws. And the bylaws of the society. And by issuing notice as per the resolution of the Board of Directors. So subsequently, one, Mithuranjan Ras was appointed initially as Secretary of the Petition Society temporarily, and thereafter, with the approval of the respondent number 5, appointed him as permanent secretary of the insert secretary, temporarily no, insert secretary, as the permanent secretary of the Petition Society on 13/1/2026. Post of Mr. Chaudhary has thus contended that, has pointed out that there is, as the appointment of Mithuranjan Ras as the secretary of the Petition Society has been approved and was after approval of the respondent number 5 and the order dated 22/6/2026 is silent about the appointment of Sri Mithuranjan Nath as the secretary of the Petition Society, and Mithuranjan Nath is presently serving as the secretary of the Petition Society, there shall not be any interference to such situation. Post of issue notice returnable on so and so, as so and so appear accepted. No formal notice, extra copies. Step 7, respond number 6 by registered. Anybody appearing? No. Steps of respond number 6 by registered speed post within 2 working days from today. The impin order mentions that by the impin order, the chairman of the Petitioner Society has been directed to follow due procedure for taking action against the respondent number 6 with an post of the respondent number 2 has observed that it appeared to the respondent number 2 that due procedure was not followed while relieving the respondent number 6 from the post of secretary. Post of in view of the present fact situation obtained in the case, it is observed that since the present secretary was appointed subsequent to approval, is stated to be appointed subsequent to approval accorded by respondent number 5 to the board resolution, it is ordered that status quo as regards the position of the secretary be maintained in the returning.
7 September 0709. Item 57.
Please, your lordship. Lordship, there's a caveat needs to be discharged.
Page,
Appearing for the caveat.
aviator.
Yes. But I have not been implemented as party necessarily.
Not required.
I'm required because my interest will be affected.
How?
This matter pertains to cancellation of my ST certificate.
In a complaint against her SC certificate, therefore my proceedings called held and thereafter.
May not be,
My lord,
may not be.
speaking order. is there.
Your presence, firstly, this is against the speaking order passed by the state level scrutiny committee.
Mine.
If you want to get, it is his choice. If you want to get yourself implemented, it is another matter. Right? But privacy,
Because another matter, I have
it is his,
challenged her selection. I have challenged her selection as Mr. Professor. And that pertains.
you
pending.
can get yourself implemented, no issue.
I have to file an.
That if this
Reply also.
inquiry is initiated on the basis of any complaint lodged by you, that is, you can implement yourself. Now, what is the case?
My lord, my mother belongs to the Dimasa community. The Dimasa Kosari community. She is a scheduled tribe. My father is not. My lord, I was born, brought up as a Dimasa. My father was later adopted by a Dimasa gentleman and given the title of Langthasa. And along with my father, all the offsprings have been accepted by the Dimasa community as members of the Dimasa tribe. There is a public meeting which is attended by the Gauhbura as well as the government Gauhbura. There are two Gauhburas there. I have annexed those. Pursuant to my being born, I was brought up there at Difu under the Dimasa tribes and customs. That is one part. The other part, my lord, is that because my father had married a ST lady, he was shunned out from his house, from his family. In fact, it went to the extent that he was not allowed to perform the last rites of his father, which I had mentioned here, my lord. And he has been deprived of his share in the ancestral property. They are not allowed to take part in the religious and social functions of my father. So now, my lord, there is a government notification. If my lord comes to page 33, this starts, my lord, at page 32. This is a circular from of 1989. It starts at page 32 about issuance of SC and ST certificates. My lord may directly come to page 33, the relevant portion. Para 3. For the guidance of the Deputy Commissioner Subdivisional Officer, some pertinent points relating to the ascertaining of caste in certain types of cases are stated below. A, caste of the person does not change by marriage. B is relevant here. The offspring of a couple.
So what about your father?
My father is a forward caste. He is Kakuti.
Yes. So A by marriage did
No,
not change.
No, my
Now
father,
regarding adoption, we don't know. But by marriage, his caste cannot be changed.
It cannot be changed. He has not got any ST certificate. It is only the offsprings and my mother who has the ST certificate, and the offsprings, that is the petitioner and her siblings, they have the ST certificates. B here is relevant, my lord. The offspring of a couple where one of the spouses belong to the SC or STP or STH of Assam does not automatically belong to SC or STP or STH of Assam, as the case may be. The caste of the offspring in such a case will be SC or STP or STH of Assam, as the case may be, provided it is found by factual verification that the offspring has been brought up in the SC or STP or STH, as the case may be, of Assam's social customs and environment. The concerned ST or STP or STH community of Assam, as the case may be, has accepted the offspring to be belonging to the SC or STP or STH community of Assam, as the case may be. Otherwise, the offspring will not be treated as belonging to SC or STP or STH of Assam, as the case may be. So here, my lord, it does not automatically confer the certificate. He has to be brought up in the customs of that particular tribe or the caste. Now, my lord, if my lord turns back a few pages, there is a public meeting at page 26.
It's the minutes of the meeting. This is in 2005. Today, my lord finds it. Today on 19/6/2005, Sunday, in presence of all the public of Dhilai, Mithipang, Dimasa Gaon, and in
No,
the
Mr. Nair,
my lord.
procedure is laid down in Madhuri.
Yes, my lord. My lord.
Firstly, was there any show cause notice?
Yes, my lord. It was the inquiry report
Whether
is there.
before that show cause notice, any inquiry by
Yes.
the concerned police
Yes, my lord. It is.
officials or not?
Yes, my lord. Page 48, my lord.
Page 40.
It's a report, my lord.
Because it says, thereafter we have to read together para 4, page
My-
33.
My lord.
If a specific written complaint
Yes.
relating to caste certificate
My lord.
is there,
My
and
lord.
that has to be inquired into.
It has to be.
So this has to be inquired
My
into.
lord. My lord.
Now again in Madhuri Patil, this may not have, Madhuri Patil is of which year?
1994.
So basically, this office memorandum will be superseded by the proceeding
By
in
Madhuri Patil.
Madhuri
Yes,
Patil.
my lord. But
Right,
my
this is 89.
my
So Madhuri Patil.
my lord is right.
So then Madhuri Patil firstly is some special inquiry by
Yes.
special something.
my lord.
Thereafter, it is to be placed before the competent authority.
My lord. My lord.
And if satisfied to go for inquiry,
My lord.
a show cause notice.
My lord.
And reply to the show cause
My
notice. Personal hearing.
Before the
If
verification by the vigilance officer. Verification by the vigilance officer.
no, after the show cause notice also,
Yes, ma'am. The second
you are
notice
afforded an opportunity along with
Yes.
a copy of the inquiry report
has to be furnished.
furnished. Thereafter, you can have the choice of filing a reply to the show
My
cause
lord.
notice
My lord.
and ask for personal hearing.
My lord.
Thereafter, scrutiny committee will hold a meeting.
My lord. That has been done.
Done.
That has been.
So those parts are there.
It's over.
Now, first authority
My lord.
in the form of police,
My lord.
that is a fact-finding authority.
Yes, my lord.
The state level scrutiny committee
My lord. My lord.
is another fact-finding authority.
My lord. My lord. My lord.
We are into certiorari jurisdiction.
My lord. My lord.
Little facts
My lord.
taken into account
My lord.
or detailed facts taken into account.
My lord.
Normally,
My lord.
court in certiorari
My lord.
will not
Yes, my lord.
disturb finding of fact.
My lord.
Now let us have the impugn order.
My lord. Before the impugn order, if my lord comes.
Let us see first
My lord,
impugn
my lord.
order.
My lord. My lord. My lord.
These are all
Yes, my lord.
adoption. We are not going into
My
that.
lord. My lord. No, my lord.
Your father, your grandfather adopted by Dimasa society or Karbi society,
My
we are
lord.
not into
My
that.
lord. Page 59, my lord, is the speaking order. The impugn order.
Yes, Mr. He is the person who heads this state level scrutiny committee. This authority is under that particular department.
My lord. My lord.
In other two cases, they are appearing.
My lord, Mr. Chaudhary was served and
No, Mr. R.M. Das.
Iron Dance.
Who, Mr. Chaudhary?
B. Chaudhary. B. Chaudhary. Along with the government.
B. Chaudhary is not one.
Doesn't reflect.
That will be an ex parte completely.
My lord. Then, my lord, could it be taken
File an amended cost title.
My lord,
Day after tomorrow, file an
my lord,
amended.
state level scrutiny committee director, they are there, my lord.
Because
Social justice, my lord. My lord, Department of Tribal Affairs is number 2.
no, that tribal affairs.
Because this is social justice, my lord, will be OBC.
Tribal affairs.
This is tribal.
That will
ST.
do. No. If it is, see, the other one is OBC.
Yes, ma'am.
And this one is ST.
ST.
So ST, if it is tribal affairs, is the nodal department or not? Oh, it is there, he is there.
He's, my lord, here, the impugned order, my lord, is by the Undersecretary, Department of Tribal Affairs.
So it will be
Tribal Affairs, not
Mr.
social.
Dhar.
Mr. Dhar.
You serve it.
My lord. Then
We'll
could
take
be
up.
taken up tomorrow, my lord. Where's that?
What is the urgency?
My lord, the other case, writ petition is pending, my lord. Wherein I
When
have
it
been
is
selected.
listed?
My lord, today it was listed.
Then what happened?
And my lord, it's fixed on 6th.
6th. Friday will take up.
Friday, my lord.
Okay.
I can find the impeding
It
petition,
is up
but
to
it will
you.
not come.
PD Nair Senior Counsel is stated by Mr. And who will, okay, 1 to 4 is, 1 to 5 is Rahul Ardhor. Okay. Huh? Tribal affairs, all are tribal affairs. 1 to 5 is tribal affairs only. And Mr. S.S. Roy, landed junior government advocate for transport number 6. Mr. Roy has submitted that a copy of this writ petition along with the annexure is to be served to Mr. R. Dhor, landed standing counsel, tribal affairs department. Mr. So-and-so, landed counsel for the petitioner, shall serve a copy of this writ petition to Mr. R. Dhor, landed standing counsel, tribal affairs department by tomorrow. List the case Friday. The name of Mr. R. Dhor,
Monday, my lord.
landed standing counsel.
Monday,
You have no jurisdiction.
because I'm the caveat.
You have no jurisdiction.
Caveator, that's all. Necessary party, they have been different.
I am not arrived at an opinion that you are a
Because
necessary
I
party.
am the complainant.
Maybe. Please don't
Monday.
disturb the flow of the dictation.
Okay, my lord, sorry then.
Huh? Online standing of the Tribal Affairs Department is to be reflected in respondent's side. Ms. Shoikia and Shoikia Learning Council has submitted that a caveat has been filed against the order impugned in the present writ petition. And appearing for and she appears for a caveat. Your presence is recorded. Locus is not determined.
The caveat may be required to be discharged, my lord.
Caveat is not before this court.
If the causes is shown, my
Is it? Okay, then we will make them party. Then you file an amended cost title.
my lord, they are not necessary parties, my lord. If they choose to appear, my lord, it's on them, my lord.
No. My right will be affected, that's.
Okay, we'll hear, the court will hear the caveator as an intervener.
My.
As an intervener.
Okay, my lord. If
As
you
an
will not
intervener.
make Party, my lord, I have to file an impeding petition tomorrow, my lord.
It is up to
If
you.
yes, my lord.
Right of an intervener
problem.
is different and party respondent is a different.
My
It is up to you.
complainant, they impugn order.
I'll hear you as a caveator intervener.
On Friday, man. DPM.
Time being method, item 9.
Your key division mentioned judgment yourself or more key judgment. More key judgment yourself. More key decision. More key decision.
My lord, your lordship asked for this writ appeal order, my lord. That we have found.
Mr. Sheikh,
My lord.
just a query of the court. Whether this eviction process carried out on 8/6/2025
My lord.
was without any notice.
Yes, my lord.
Where have you stated?
My lord. Your lordship. Your lordship will turn to page 13, my lord.
No, any notice. And you made any statement that no notice.
Paragraph 17.
Okay, paragraph 17.
Para 17 also and this.
Paragraph 17. In the case.
17 is. In the case in hand, no notice of evictions were issued to the petitioners before evicting them from the Schedule A to Q land. We see clear violation of decision of rights.
Yes, Mr. Division bench. Division bench could have granted the stay. Why it is demanding the matter? Huh?
But that is really.
Hasn't given any positive. This aspect is to be considered. Because the divisions bench had the same power to grant interim order.
I could not find any order 29/12/25
Hmm?
that they have challenged.
Which order challenged?
Page 19. that's
19.
Part of the prayer petition, prayer portion.
Rejection order 5/4/2025. Heard Mr. M.E. Sheikh, learned counsel for the petitioners.
Because that is the order by which the pata has been issued to APTC. That has to be put to challenge. They have put to challenge, but I could not find where they have annexed.
You filed your response then. On one ground, division bench has said large chunks of lands are available, I don't know. Something is there. They have said, they have found large chunks of land are available for everyone to squatter. So we'll notice this observation of the division bench, right?
Don't be out. Action means what? The approval of this. You see earlier portion, then page 52.
No, where in the page, Mr. Sheikh?
My lord,
Page 62, where is the status quo order?
62.
You are showing time and again a order of the coordinate bench.
My lord,
Where is that status quo order?
my lord, not the
Huh?
status. My lord,
Where is the status quo order?
what was what I was on? That actually the government cannot exercise power under Rule 50. That was the thing. I did not submit before your lordship that I am entitled to status quo on the basis of coordinate benches. That is not my case. Yeah, my lord, after this division bench order, my lord, division bench clearly said that if stay is not.
Where is the status quo then?
My lord,
Because division bench said
my lord,
you because say that the coordinate benches are granting status quo orders. Where is that?
my lord, I am coming.
That is not status quo order.
My lord, your lordship would be pleased to see.
No,
It is taken
the division bench has said.
entirely regarding civilian bench. Your lordship will be pleased to see.
No, so far,
Be
Mr.
that
Sheikh,
as it
Mr. Sheikh,
My lord,
you
be that
said
as
in
it-
the morning
My
when
lord,
the petition was moved
my lord,
that patta was issued to APDCL in December
my lord,
and June it was eviction,
my lord.
right? So, para 11 of the order of the coordinate bench is not applicable because after eviction,
My lord.
government land can be allotted or settled
Right.
with any other person.
Right.
So that I'll clarify now.
My lord.
Now, where is the status quo orders? Where you have represented before the division bench,
My lord,
right?
my lord.
That the settlers have been given status quo orders.
My lord.
Where is that?
No, my lord.
Show us.
Your lordship would be pleased to see. That was not my submission. Your lordship would be pleased to see overall land. Most of the cases, status quo has been passed. That is the observation.
Where is those?
Be that as
No,
it
where
may.
is those?
My lord, my lord.
Coordinate benches are passing status quo orders. Where are those?
My lord, that is not in my hand.
Not in then where is those?
No, my lord. Your lordship would be
Get those
pleased to-
status quo
My lord.
orders. You are asking for status quo orders and pass status quo orders.
My lord, your lordship.
Absolutely, no doubt.
My lord,
But
your
the order, Mr.
Wha-
Sheikh, please be. This order I have read again, page 62
My lord.
of the coordinate bench. There is
Coordinates-
nothing like status quo order.
No, my lord, I have not said that coordinate
Then-
bench given me status quo.
Then
That
this
was-
division bench observation.
My lord, that
That,
was not my submission. In the
No.
in the morning, my lord, that
Do you
was
have
not
the
my
order?
submission.
Do you have the order of the
My
division
lord,
bench?
division bench, I will come, my lord. But
Okay.
I am, let me,
No, let us have the division bench.
my lord,
Because,
let me clear the position regarding coordinate bench, my lord.
yes,
Yes, regarding coordinate bench, my lord, my submission was this. That land is now Medipatta land. We are continuing possession on Medipatta land. Whether government has got power to exercise power under Rule 18, again they will evict us.
now the land is Medipatta land. We are continuing on Medipatta land. Whether the government will exercise.
Yes,
power.
when the patta has been issued in favor of the APDCL,
Yes, madam.
Mr. Patasai, when the land was settled with APDCL,
December, my lord. That is on record.
December,
December 2025.
and eviction,
Yes.
Eviction thereafter.
eviction thereafter.
Yeah.
Okay. And there is no status quo orders by coordinate benches?
Not my lord. And I did not pray before your lordship in the morning, my lord. I pray only for that.
I'll
We-
clarify,
Yes,
I'll
madam.
clarify this part, paragraph
My lord. And regarding-
11.
Regarding.
11, I'll clarify.
My lord, now.
Your case regarding eviction
My lord.
without notice
Yes.
will be examined by this court
My lord.
as per your assertion,
My lord.
subject to their counter
My lord.
that it was an eviction process without any notice and opportunity of being heard.
My lord.
Right. If it turns out notice and opportunity, then your re-entry thereafter in the same land is absolutely illegal.
No.
Now,
Here, my-
I even say,
actually-
I'll pass the similar order.
My lord.
I'll absolutely pass similar order as my coordinated bench.
My lord.
Further clarifying that eviction process was carried out in 8/6/2025 and the patta in favor of APDCL was issued in December 2025. Only I'll add this line. Heard Mr. M.A. Sheikh, learned counsel for the petitioners. But when this matter is remanded by Mr. Sheikh, if it comes to me, you have to place the status quo orders.
My lord, here, my
The
lord.
division bench matter is remanded back.
It is late hours, my lord. Maybe your lordship
No,
will
no,
allow
no.
me 1 minute.
No, no, no.
1 minute regarding
I'll pass the
this.
same order.
My lord.
No, you don't have to be
My lord.
worried.
My lord.
Mr. A. Bhattacharya, Revenue 1, J. Hendik 2, 3, 4, 6 and 7. Miss, on behalf of U.S. Standing Council, B. Das. Passport number 6. Okay. Mr. Sheikh, learned counsel for the petition has submitted that the case of the petitioners is similarly situated to the petitioners in WPC number 1793/2026 and a similar order as passed in the said writ petition on 31/3/2026 be passed in the present writ petition. Notice. A 5105 6 writ petitioners. And respond number 5, respond number 5, okay. Paragraph 6, okay. Paragraph 7, okay. Paragraph 8, okay. Mr. Bhattacharya and Mr. Hendik, 3 number paragraph, have submitted that the eviction process against the petition was carried out on 8/6/2025 and the land, parcel of land was allotted in favor of, allotted stroke settled in favor of the respondent of 5 in December 2025.
29/12/2020.
Order for correction of land records in favor of APDCL. was
Order
recorded
for
as-
correction of land records for the same parcel of land was passed on.
On 29/12/25.
তাৰপিছত বাকি paragraph saves paragraph 10, paragraph in the paragraph 11 of right. In the order dated 31/3/2026, passed by the coordinated bench in WBC number 1796, the court had observed, without commenting on who was in possession of the land, that as the land had already been allotted to the respondent of 5, the state respondents cannot resort to the powers under Rule 18 of the settlement rules. Post of para. From it is a submission of the land council for the parties that initially the eviction process was carried out against the petitioners on 8/6/2025, and there has been re-entry of the petitioners in the same parcels of land. Post. The land records for the parcel of land measuring has been made only subsequently in 29/12/2025 for correction of records. Post. Same order, exactly ditto. Ditto. Right?
2nd September 0209.
No change. Only clarification.
My lord.
But when this matter is remanded back, you show me the status quo orders.
I'll try.
On the basis of which you have made the matter remanded back. Sorry, could not complete. If any interim orders are to be extended, please inform.
Milods, in items 23, 24, Milods, in 2 read petitions, interim order.
Your lordship, in item
Due to
number
paucity of time, the cases could not be taken up today. Interim orders, wherever passed earlier, shall continue till the next date of listing. List the cases on 23/24. Be rewarded.
19th August. 19th July.
your lordship,
Well,
19th.
it's-
19th.
21st August. 19th.
Any interim orders anywhere?
In item 43, my lord.
43 R. Sharma. And the state council are present due to paucity. The case could not be taken up today. Place the case on after the interim order passed area shall continue till the next date of listing.
10th August 1008.
Item number 32, my lord.
32.
Item number
30.
32.
Okay. Any counter is filed?
Yes, sir. File, my lord.
Huh?
Pending is exchange.
Okay. R.S. Mishra, petitioner. And Mr. H. Borua. Huh? On behalf of B. Gogoi. Huh? For the respondent, Finance and Taxation Department are present. As sought for, is the case on so and so, the interim order passed earlier shall continue till the next set of listing. This is
19th.
pay item 32.
19th August.
On a request of Mr. You are respondent or petitioner?
I'm petitioner wrongly shown in other side.
Okay. Request of Mr. J.M.A. Chaudhary and counsel for the petitioner, list the case on so and so.
Item number 33, your lordship, intended to be.
17 August.
Okay. Any affidavits are filed?
No, your lordship.
Hmm?
No, your lordship.
Mr.
J. Das.
J. Das, learning counsel for the petitioner is present. Who is there in the for respondent? No affidavit, counter affidavit on behalf of the respondent has been filed till date. First of let the case be listed on so and so, 3 weeks of DDO for filing of counter affidavits by the respondent. You are there in 30.
No, my lord, I am for.
The interim order passed, I shall continue till the next date.
The date only, I am seeking a date, my lord. In
24th August, 24th August,
Item 35, my
24th August.
What is the case about?
my lord, freezing of account.
Freezing. Bank has appeared.
Bank appeared, my lord, they said they have instruction.
Okay, DDO.
My lord,
Please,
may I make a mention, my lord? Lordship, item number 30. Item number 30, my lord, this matter is about rejection of our passport application on the ground that criminal cases are pending. My lords, due to subsequent developments, this case has become urgent and there is a deadline now, my lords. Therefore, I'm praying that this case may kindly be taken up on Monday, my lords, if possible.
Okay, Monday.
Monday.
You are Mr.
A. Sahu, my lord.
My lord,
Yes.
I am for the respondent number 3 and 4, state of money.
Item 30.
Yes.
Okay. Sahu, A. Sahu, petitioner. And annexed thing. For 3 and 4. Mr. Roy is there? No. Okay. Mr. J. Hendick, State Council. Leads the case on Monday.
3rd August,
So good.
0308.